Yes. Where's my list? Items?
Item 7, 8,
7, 8, 9?
7, 8,
Oh, 27. These are challenging some rules or something. At the request of the Mr. A. the learned hearing on behalf of the petitioner, matters that adjourned to be listed up 2 weeks.
Here item 14 and 15 motion.
Yes.
On behalf of Kipa Lordship, not Mitsu Lordship.
14 and 15.
Lordship.
Why? Why?
This is
We'll see when the matter reaches. Let's take up the matters of the matters.
Lordship.
For admission, item number
Yes, any affidavit filed by the state?
Yes, Your Lordship, I filed this one.
Yes, where is it? No, not this one. It's a single bench matter. Mr. Khalid, kindly put yourself in. Yes, where's the affidavit? You have a copy of it, anybody? So what is the status in respect to the works in question?
My lord, I annexed the status of works of the Regularization subdivision as of the 2nd February 2024.
We'll take it up after some time, once we have that affidavit. Pick up the next time. It's the single bench method.
for admission, item number 2.
Yes, response number 1 and 3. Yes, what is the status of the supplementary nutrition?
Lordship, yeah, as per the order dated 21/2/2024, I have received instruction, Lordship.
Yes.
Yeah.
What does it say? You have a copy of the instructions?
Lordship.
Yeah, give it to us. Instructions.
So the rule S&P Rule 2017, Section 5 is.
I'll be filing my affidavit today. I have received the affidavit.
You have received the affidavit?
Yes, Lordship.
Okay, you have a copy of it?
Yes, sir.
Now give us the copy. You filed the affidavit, it's a different thing, give us a copy. Yes, madam, what do you say about these instructions?
Lordship,
You
sir,
see, from the affidavit which is being filed with the union, it seems that all the provisions have been duly given to the state. As you can see from that, you have a copy of that affidavit?
Lordship, I haven't received a copy.
Okay, give it to her, that affidavit. Let us. See, they have a particular scheme. And you come to paragraph number 6 onwards, which is a strategic shift in mission mode to develop practice that nurture health, wellness, and immunity for malnutrition, whether and so have been realigned under so for maximizing the nutritional outcomes. The guidelines for the schemes have been issued in so. The mission will focus on the fundamental importance of the nutrition in early so. Now, what are the vertical things which are being given? Given primary, portion 2.2 is nutritional support for portion through supplementary nutritional program for children for age 0 to 6 years to answer. Early childhood care and education for the children of so Anganwadi also. Then these are the various facilities which is at paragraph number 8. Then if you see the paragraph next, at paragraph number 12, there's a tracker application which was launched on March 2021, and there you see who are the beneficiaries in the state of Nagaland as on September 2023 has been given. Then the amount of money which have been released to the state of Nagaland is being given. And thereafter, you see that in addition to for fund maintenance, this is being given.
Lordship, sir, if I may.
Hmm.
Kindly this affidavit be filed and also give me time to peruse the same.
Yes, no, I'll give you.
Yes,
For that,
Lordship.
don't worry with that. I'm just putting it to your attention.
Lordship,
Today
I'm
you are
obliged,
filing that
Lordship.
affidavit? Okay. So then on the basis of that, I put it in the order,
Yes.
what they are doing. And you will file your reply out here if you have anything to say.
Lordship, yes, your Lordship.
I think that is a better off.
Lordship.
And the government has also produced an instruction out here that these are the things which are being presently given. And in that regard, she has also given the, as on the month of December 2023, this is the present status. You have a copy? Has been given
No,
to you?
no, I don't know my
Give
thoughts.
her a copy of that, and on the basis of which you. The instant public interest litigation has been filed seeking appropriate directions to provide hot cooked meal to pregnant and lactating mother for the number of 300 days as prescribed by the Supplementary Nutrition Rules 2017, semicolon, to provide take home ration for children between 6 months to 36 months as prescribed in Rule 5 of the said rules of 2017 for 300 days, and the same type of take-home ration to be supplied to the malnutrition children between 6-36 months with food supplement of 800 calories and 20-25 grams of protein, semicolon, to provide morning snack and hot cooked meal to children from 3-6 years for 300 days as prescribed by the rules of 2017, and the same type of take-home ration be supplied to the malnutrition children between 3-6 years with additional 300 calories of energy and 8-10 grams of protein in addition to the meal provided, and for further directions pertaining to the food security allowances to the pregnant woman, lactating mothers and children. In addition to that, the petitioners have also sought for providing kitchen, toilet and access of drinking water and tap water connection from the reliable source to prevent disruption of cooking meals for eligible persons. When the instant writ petition was listed before this court on 21/2/2024, this court directed the respondent numbers 1 and 3 to apprise this court as regards the present status relating to implementation of the Supplementary Nutrition Rules 2015 or 17?
2017, but
2017. Before that, this court, today, Ms. A. Santam, the learned counsel appearing on behalf of the Social Welfare Department, have produced certain instructions. Before dealing with the said instruction, this court finds it relevant to take note of that the central government, who is the authority, and the central government under whose aegis these schemes have been rolled out, have filed an affidavit. In the said affidavit, the central government, you are filing it now, no? Yes. It's already done.
Yes.
You filed it.
Yes.
No, I will take it as it has been filed. I filed the central government. The central government Mr. Youngworthy, the learned counsel appearing on behalf of the Union of India, have produced an affidavit which is in the process of being filed during the course of the day when the matter was taken up for hearing. In the said affidavit, it has been mentioned that the Integrated Child Development Service Scheme, for short, the ICDS, is a central sponsored scheme which was launched on 2nd of October 1975. It was further, the Union government is responsible for the program, planning and infrastructure cost, and the state the Union territories are responsible for the program implementation. Various guidelines have been also issued by the Government of India from time to time for proper implementation of these services, including other components, and modified the same on the feedback received from the state the Union territories as per the requirement, and to ensure proper implementation of the scheme. It has been mentioned in the said affidavit that the Government of India had since approved, inverted comma, Saksham Anganwadi and Poshan dot 2.0, inverted comma close, which is a strategic shift in mission mode to develop practices that nurture health, wellness, and immunity from malnutrition. The Anganwadi Services, Scheme for Adolescent Girls and Poshan Abhijan have been realigned under Poshan 2.0 for maximizing nutritional outcomes. The guidelines for the scheme have also been issued on 1/8/2022, with giving focus on the fundamental importance of nutrition and early childhood care and education for the well-being, growth, and development of children into healthy and productive adults. It has also been mentioned that the portion 2.0 has been reorganized into primary verticals, which were, number one, nutritional support for portion through Supplementary Nutrition Program, bracket SNP, for children of the age of 6 months to 6 years, pregnant women and lactating mothers, bracket PWLM, bracket close, and for adolescent girls in the age group of 14 to 18 years in the aspirational districts and the northeastern region. Number two, early childhood care and education for children of 3 to 6 years and early stimulation for 0 to 3 years. Number three, Anganwadi infrastructure, including modern upgraded Saksham Anganwadi. And number four, Poshan Abhijan. It has also been mentioned that the Anganwadi service schemes provide various packages of service in an intricate manner to the eligible beneficiaries. The 6 services were Roman 1, supplementary nutrition, Roman 2, preschool non-formal education, Roman 3, nutrition and health education, Roman 4, immunization, number 5, Roman 5, health checkup, and Roman 6, referral service. It has been stated that these 6 services, viz. Immunization, health checkup, and referral services. Now, it has been mentioned that 3 of these 6 services, that is immunization, health checkup, and referral services, are related to health and provided through the National Health Mission and public infrastructure. Services are delivered through Anganwadi workers and Anganwadi helpers at the Anganwadi centers. The scheme operates through a network of 7075 fully operational projects and more than 13.96 lakh Anganwadi centers across the country. It has also, the said affidavit also specifically deals with the state of Nagaland, and it is mentioned therein that in the state government, in the state of Nagaland, the details of Anganwadi projects and Anganwadi centers as on September 2023 are 60 Anganwadi projects which are operational and 3980 Anganwadi centers which are sanctioned and are operational. Further to that, it has been mentioned that as regards the components under the Anganwadi service, the central government implements the same through a cost-sharing ratio, and in respect to the northeastern region, for general Anganwadi services, it is 90:10, and for supplementary nutritional program, it is also the same ratio. Further to that, it has also been mentioned that the POSHN tracker application was launched in the month of March 2021, which is an integrated application which facilitates near real-time monitoring of service delivery in relation to service provided to target beneficiaries, which includes pregnant women, lactating mother, and children of the age group of 0 to 6 years, and adolescent girls of 14 to 18 years in northeastern region and aspirational districts. Footstep. In the state of Nagaland, as on September 2023, as per the said affidavit, there are the following details is being given as regards the beneficiaries. Footstep. Here, page 8. This is the table. Further to that, in the said affidavit, details of fund release to the state of Nagaland since 2018-19 have also been mentioned in respect to the Anganwadi service schemes. The details are as hereinafter. Also, in addition to the above, the Anganwadi centers and in addition to the above, there are separate funds also released for maintenance of Anganwadi centers and for providing toilets and drinking facilities in the Anganwadi centers to the state of Nagaland, which is also as hereinafter. It is also seen that the central government had also released funds to the state government of Nagaland under the Poshan Abhijan for nutrition and other components, and the details are as hereinafter. The affidavit also speaks about the release of funds to the state government of Nagaland under the scheme for adolescent girls, and the released funds to the state of Nagaland for the last 5 years is as hereinafter. It is also, apart from that, in respect to funds allocations, funds to be allocated for, which have been allocated for food grains under the scheme of adolescent girl to the state of Nagaland for the last 5 years is also mentioned hereinafter. The said affidavit also states about the allocation of food grains under the scheme for wheat-based nutritional program to the state of Nagaland during the last 5 and current year, which is also as hereinunder. From the affidavit of the central government, it reveals that the state government have been allocated various funds. The question herein is as to whether the funds which have been released to the state government have been utilized in the manner in which for which the same have been duly given, allocated and disbursed. The state government is directed to file an affidavit as regards the utilization of as to whether the funds have been utilized for the purpose for which it have been disbursed by the central government. This court further takes note of and the instruction which have been produced by Ms. A. Sangtam, the Council for the Social Welfare Department, wherein it has been mentioned that the rules of the Supply Nutrition Rules 2017 have been implemented by the Department of Social Welfare across the state of Nagaland as per the given guidelines. It has also been mentioned that the department implements the said scheme through the Anganwadi centers, and presently there are 3,980 Anganwadi centers along with 3,980 Anganwadi workers and helpers. Further to that, it has also been mentioned in the said instruction that under the program, the food items are supplied, provided through Anganwadi centers are, number 1, take home 6 months, 3 years, lactating mother and severely malnutritioned. Number 2, hot cooked meal, 3 years, 6 years. Morning snack, 3 years, 6 years. It has also been mentioned that the program is implemented in all the 60 projects of the ICDS, and the total population receiving the benefits, receiving the food items are 6 months, 6 years, 3,69,738, and pregnant and lactating mothers, 41,384. The said instructions which have been submitted before this court is kept on record and marked with the letter X. Okay. The learned counsel for the petitioner submits that from the affidavit which has been filed by the Union, which is in the process of being filed by the Union of India, and a copy of which have been also served upon her, shows that the Union of India have released various funds. The question, however, would arise as to whether the funds have been utilized in the manner in which it has been disbursed by the Union of India. In that regard, she submits that she will seek some accommodation for bringing to the attention of this court as regards how the funds have been utilized. Taking into account the above, the matter stands. How much time?
2 weeks, Lordship.
Okay. The matter stands adjourned. The matter would be further taken up for consideration on 13th of March 2024. 2 weeks.
Lordships.
In the meantime, the petitioners is given the liberty to file additional pleadings. Apart from that, as already observed here in above, the state government shall file an affidavit as regards as to whether the funds which have been allocated as stated in the affidavit by the central government have been utilized in the manner for which it has been disbursed.
Obliged, Your Lordship.
Mr. Yangawati, you filed this?
I'll find it today.
Okay. Yes, take this.
Item number 1, the affidavit
motion has been rejected for defects. So, as per the brief policy. You give that, this order, you are filing it now, no?
I will find it today.
Don't file it in the late hours. It will be difficult, no?
I will find it today.
Then you give us this copy for the time being,
Okay.
so that she can type out
Yes,
these
yes.
paragraphs.
Yes.
You file it.
For admission, item numbers 3 and 4.
We start. Okay. Lordship,
Hmm.
this item number 2, 3, 4, 3, 4, 5, and 7. They were clapped together. So, clap with them. No, I'm sorry. I'm sorry.
This is as regards implementation of this project. What was that? Huh?
RKSK, providing something that can be.
I've asked you to put it by way of an affidavit.
Yes, what I already said.
You filed the affidavit?
Yes.
Oh, yes.
This distribution of the
Statement made in an
implementation of the RKSK scheme, mentioned item scheme under the district for financial year 2024.
So you have only implemented in the Kifri.
That is the pilot district also. And we are planning to go to other district also. We are starting from this district. Because as per the guideline of the Government of India, Lordship, we have to do phase wise. I've stated in my affidavit.
So whatever reliefs the petitioner is asking,
Lordship,
it has been now only implemented in Kifri.
and we'll be going to other districts.
And you are going to go for the other districts when?
Lordship, that we have already stated in our affidavit, Lordship. The pipeline.
In the pipeline. Where is the pipeline? Where is the affidavit?
Lordship,
Affidavit by respondent number 1, 2, and 3.
yes, thank you.
And what do you say about the portion? Because in the earlier matter, you must have heard it. There are 3 things which NHM is doing. You are NHM. NHM is doing 3 things. One is, madam, you have the copy of the earlier affidavit?
Yes, Lordship.
You have the copy, just see out there in one of the paragraphs, I think paragraph 13 or 14, earlier matters, the government's affidavit. Yes. Paragraph 13 and 14, there are 6 items which are there. And of which they are saying that 3 things are being done. You see? There are 6 items. Supplementary, so and so, number 1, 2, and 3. And the last.
The supplementary nutrition, preschool, non-formal education, nutrition and health education,
immunization, health checkup, and referral services.
Yes, the last three.
Yes, Lordship.
The last three is being done by NHM. This is under another scheme, Poshan. This is again done under the Poshan scheme.
That will come under the RCH, Reproductive Child Health. But this is again a different scheme, RTE scheme. In a way or other, Lordship, all these.
These are interconnected, Lordship.
Interconnected, Lordship. So all the schemes go.
No, I
hand in
think,
hand.
not on that regard, of why I didn't say on that aspect, but I said only on the aspect that now there is an application.
Lordship.
Now, on the application which is there, which have been launched in March 2021,
Lordship.
are these benefits which are there are being brought within the ambit of that
Lordship,
application?
because of the COVID, during the COVID, Lordship, there was a gap in the implementation of the program, Lordship, which we are still in this year so. We could not implement it because of the COVID, Lordship. But right after COVID, we have reproposed to implement the scheme. And accordingly, we have procured the items, Lordship, and now it has been distributed to the beneficiaries, Lordship. Lordship, can you come to my affidavit
Yes.
of respondent number 1, 2, and 3? Paragraph 3, page 2, Lordship. The objective of the RTE scheme, Lordship. Aim and objective. That before answering the development made in the repetition, the Arjun Department would like to bring for the notices on record the aim and objective of the implementation of the menstrual hygiene scheme and the reason for non-implementation by the department. Rashtriya Kishore Swasthaya Karyakaram, hereafter referred as RTSK, is a new adolescent health program which was launched in the year 2014 by the federal government, which includes menstrual hygiene scheme to increase awareness as well as access to use and safe disposal of highly.
So this is only limited to rural.
Yes, rural areas.
But the earlier one, madam, is not to rural. The earlier one
Overall, Lordships.
is not for rural, but this is for rural only.
Yes.
Lordship, in fact, ICDS is for both the rural and the urban area.
That is what,
Lordship.
so it includes everything.
Yes, it includes everything, Lordship.
There also you have this giving of the sanitary napkins amongst the adolescent girls
Lordship, yes.
in that thing. Also
Yes.
you have it, but here it is limited only to rural. Because as it is seen from here, it says access and safe disposal of high quality sanitary napkins amongst the adolescent girls in rural areas. This affidavit was filed in 2022.
Yes.
Why we are still in Kifri? Not proceeded any further.
Lordship,
The pilot, why we are still with the pilot, not with the passengers?
Lordship, as far as the program is concerned, Lordship, a target was given to us, a pilot district. So we have targeted different district, taking consideration of the remoteness of the area.
But isn't it 2 years? Why is it taking 2 years for that to come by here? Because let's see the scheme of the government. The scheme of the government, does it say, the central government, does it say that it will take so much of time? Is it mentioned anywhere that it will be given into a aspirational district first and thereafter it will be proceeded? Where is the scope? Where is the scheme?
Lordship, menstrual hygiene scheme, along with the notification is annexed in page number 127 of my petition, Lordship.
Of the writ petition, page 127.
Yes, Lordship.
Paragraph 2, Lordship. States within may project their fund requirement for procurement of sanitary napkins in state BIP, expanding the scheme beyond currently implanted districts. So we have to go in phase-wise manner.
No, let's read. State UT may project their funds requirement for procurement of the sanitary napkins in the state PIP, expanding the scheme beyond currently implanting districts. You see 2016. Procurement may be restricted to cover 25% of the rural adolescent girls across all the districts of the state in the initial phase.
Lordships.
Depending on the uptake of the scheme, increased coverage may be considered in the subsequent years. The increased coverage will be not on the, as regards the district, the amount, the 25% would be increased. So that is what it is there. But what is the basis of having a pilot?
No, Lordship, that is as per the program that was information that's provided to the Lordship by the Department, Lordship. And Lordship, as far as the petition is concerned, Lordship, now they are asking for implementation of the scheme.
Has the central government filed any affidavit?
No, not in this case, Lordship. Not in the other case.
Another case, yeah.
In another case, you have filed?
Item number 4.
4. No? Let us see what does the central government have to say.
Okay.
Ah.
Lordship, the only relevant portion is at page number 4. Para 8.
So you have released.
Yes, Lordship.
Lecture 1, let us see what it is. How it is being implemented. On 11/10/2023, when the matter came up before this court, your submission was that you were not in a position to do so in view of the fact that the state is not, union was not releasing the funds. And it is on account of that the union has filed the affidavit stating that for this period, they have for 2021-22, they have already released 92 crores. 22-23, 91.38, 23-24, that is up to 31/10/2023, 71.33 crores.
Lordship, this figure I have to cross-check it, Lordship, because whatever they have stated, the ROP release, Lordship.
But why are we still stagnated in Khifri district, which are on a basis of an affidavit filed in the year 2022?
Lordship,
And as per your new affidavit, it remains the same.
yeah, Kifri district.
Then nothing is developed and nothing is happening.
So, Lordship,
If you are receiving the funds from the union and there is no proper utilization of that, the union has to do something else. What do you say, Mr. Yangavati?
no, Lordship,
If they are not doing, in spite of the release of funds by you, then I think something needs to be done by the union.
It's a very huge amount, Lordship. It's
Yes,
80 crores.
and that too only on this aspect, 92 crores, 91 crores, and you are still stagnating out there.
If Lordship, if I could give this a short time, Lordship, I'll estimate the amount that is released to me, Lordship. Because we don't get the amount that they sanction. The ROP release is much lesser.
Who gets? The money has been released to you.
Lordship,
Flexible for
Yes,
RCH and health system strengthening, National Health Program and Urban Health Mission.
Lordship, as far as the fund release is concerned, Lordship, we have all the documents with us. How much we have received, Lordship? I can show the document because the amount that I show you, our whole state for the election does not, we don't get even 100 crore.
No, you
Oh,
see, no, Mr. Muzo, further see another very important aspect is we can see from this particular notification, which is there.
Lordship,
The states may project their fund requirement for procurement, because here we are only concerned with sanitary napkins. So you are to project the fund requirement and then expanding the scheme beyond current. So initially you were to have taken into account 25% of the rural population there. Then if you see, this scheme also says that Ayushman Bharat and these should be more specifically done in these places where the schools are there, where you have this say. This is in the affidavit which have been filed. Kindly see this particular affidavit filed by the union. Kindly see which are the base where it has to be done. Kindly see this, it has been mentioned, page 16. First, you are to have these clinics, then community health centers, primary health centers, sub-centers. Then also you are to have school-based approach. Are you doing anything in that regard? Yes, madam, anything done?
No, Your Lordship. In fact, since this PIL, instant PIL deals with only menstrual hygiene scheme, and the next subsequent PIL, Lordship, that deals with the larger issue of implementation of RBSK scheme, Lordship. So perhaps we can hear this case first, then go to the RBSK, Lordship. But yes, Lordship, according to your query, since we have filed RTI information, we have obtained information through RTI. Based on that, Lordship, there was only 36 clinics, adolescent health friendly clinics in the whole state of Nagaland. So, Lordship, considering the importance of the well-being of the adolescents in the state, the population is huge, Lordship. That is why the subsequent PIL was filed with a prayer to for certain intervention, especially to have more adolescent health friendly clinics, Lordships. We also, in that case, we also brought before this honorable court's present the attention of this honorable court that the condition of 2 adolescent health friendly clinics, which were not conducive, because the schemes has given a detailed guideline on what kind of facilities should be given, what should be the environment, the ambience of the clinics, Lordships.
Yes, madam, kindly come to annexure 1 of the affidavit filed by the union in the second petition.
Yes, Your Lordship.
Now
Yes,
you
yes.
see, page number 16. Stipulates that these are the things wherein they are to implement.
Yes,
this
Lordship. Lordship.
Number 2, at page 17, it has also been mentioned that you should have it as a school-based.
Yes.
Now, if we read that with this page 127 of your earlier PI,
Lordship.
you will see, yes, the implementation was initially limited to 25%, which can be increased phase-wise. But the fact that the union never say that you are only going to implement in one district or have a pilot district, no.
No,
It has
Lordship.
to be done pen state of Nagaland.
Yes.
But the question is, initially you may limit to 25% of the rural population and then steadily increase it. That's the scope. Then where is this concept of a pilot project?
Lordship, that's information I have access to. Lordship.
Understood, but you are the council.
Lordship, if necessary direction may be given that we fully implement throughout the state of Nagaland, Lordship, as per the guideline.
Because here the concept is not there, having a pilot project. The pilot project at best may be, you may say that first targeting the 25%. That might be said to be a pilot project. But when you are getting all the funds, which they are saying that the funds have been released, if you are not doing it, then I think you better do it. Otherwise, the state center has to also. You must be giving, whenever amounts are state, central grants and amount, they are very careful that it is utilized in a
Lordship,
proper manner.
appreciating what Lordship has pointed out, Lordship. But the amount released that is shown in the affidavit, Lordship, it's not by way of a government, Lordship. It's just a statement. I can agree to this, Lordship, because the money that is received by us, Lordship, it's very limited, Lordship, and it's installment.
But how can you have a pilot project? That is the question.
That's how the.
No, you can't have a pilot project. The concept of pilot project is completely foreign. If this is the letter
Lordship,
which has been given,
yes, Lordship.
And the mission director has to, you being appearing on behalf of the Nagaland Health Mission, so you are to therefore do it in terms of this communication annex 7 page 127. There's no concept of a pilot project. Both the PLs are taken up together, taking into account the similarity of the issues involved. The public interest litigations have been filed, drawing the attention of this court that the state of Nagaland, and more particularly the Nagaland, and more particularly the mission, the Nagaland National Health Mission, Nagaland, Government of Nagaland, and Nagaland it should be, National Health Mission Nagaland, have not been implementing the Rashtriya Kishore Swasthya Curriculum bracket RKSK as per its guidelines. Ms. Suenso, the counsel appearing on behalf of the petitioner has drawn the attention of this court to the communication dated 4th of March 2016 issued by the Joint Secretary, Government of India, Ministry of Health and Family Welfare to the mission directors. In the said communication, it has been specifically mentioned that the state / the UTs may project their fund requirement for procurement of sanitary napkins in the state PIP. Full-stop. Expanding the scheme beyond the currently implanting districts, procurement may be restricted to cover 25% of the rural adolescent girls across all the districts of the state in the initial phase. Depending on the uptake of the scheme, increased coverage may be considered in the subsequent years. The learned counsel appearing on behalf of the petitioner submits that the concept of having a pilot project in one district is completely foreign to the guidelines which have been issued, and more particularly the communication dated 4th of March 2016. At best, a perusal of the said communication would show that initially the exposure to the scheme may be limited to 25% of the rural adolescent girls, which would require to be increased from time to time. Full stop. This court have also taken note of the affidavit which have been filed by the National Health Mission Nagaland, wherein it is the specific case of the said respondent that the said scheme have been only implemented in the district of Khifri as a pilot project. In fact, when the matter was listed before this court on 21/2/2024, this court had directed directed the National Health Mission Nagaland to file an affidavit as to whether the scheme is implemented in the state. To the said directions, an additional affidavit has been filed stating inter alia that the state NHM had proposed implementation of the menstrual hygiene scheme at the aspiration district, that is Khifre. And in that regard, as per the Hospital Management Information System, HMIS indicator, the data collected for the financial year 2023-24, implementation of RKSK scheme, menstrual health hygiene scheme, under Khifri district for the financial year 2023-24 have been enclosed. As Annexure A. This court have duly perused the Annexure A, which shows that there has been certain distribution of the sanitary napkins to the adolescent girls as stated therein. Be it as it may, this court finds it very pertinent to take note of the affidavit filed by the Ministry of Health and Family Welfare Union of India on 7th of December 2023. The said affidavit was filed pursuant to the order passed by this court on 11/12/2023, wherein the counsel appearing on behalf of the Nagaland National Health Mission, the state health mission, had submitted that the government of Nagaland have not been released the necessary funds. In the said affidavit which have been filed, it has been mentioned that for the year 2021-22, financial year 2021-22, and for the financial year 2022-23, amount of rupees 92 crores and 91.38 crores have been released to the state of Nagaland. However, in respect to the financial year 2023-24, that is up to 31/10/2023, a further amount of rupees 71.33 crores have been released. This court also finds it very pertinent to take note of the guidelines, the implementation guidelines of the Rashtriya Kishore of the RKSK, which stipulates as to how the implementation of the said scheme is required to be made. It is stated therein that the focus should be on strengthening the adolescent-friendly health clinics at the level of district hospitals and community health centers with a physical makeover to ensure privacy and confidentiality, training of existing staff, introduction of trained counselor, and provision of necessary commodities and equipments. Full stop. This code also we also find another very important aspect contained in the said guidelines. That is, for the implementation of the said scheme, it has also to be the school-based approach was also required to be taken. Be that as it may, these aspects are not clear from the affidavit which have been filed by the State Health Mission. On the other hand, it is the specific case of the State Health Mission that they have only implemented the same in the Khifri district as a pilot project. In our opinion, the same does not seem to be in consonance with the guidelines which have been issued, as well as the communication dated 4/3/2016. Taking into account the above, the State Health Mission, that is the respondent number 4, is directed to file an affidavit as regards how the amounts which have been received, disbursed by the union, have been utilized, and further as to whether the same could have been, and further as to whether the same, as to when the said authority is going to implement the said scheme pan the state of Nagaland. List the matter again on 23/2024.
Lordship, just one clarification. The amount that has been released for the financial year 21-22, Lordship, this is for the whole RCH. RKSK is part of RCH. So it's not only for the RKSK.
That is why you reply out there in your affidavit.
Because what they're saying is under the RCH.
Otherwise, it was a case on the, I should have said out there, but this is.
For admission, item number 1.
Yes, government. In respect to the thing which have been completed as per your completion certificate of 2014, the progress as on today is 97% and the financial progress is 85%.
The lordships are placed the same on running page 9, your lordship. Last page. Yeah, read, your lordship. Status of works under Mallory subdivision as on 22nd February 2024, Peck Division, Peck District. Serial number 1.
Now, what is this upgradation of road from T01 to Kangjing? 38 kilometers.
Yes, my lord. That is under PMGSY.
This is a different person.
It's
This is being given to Nagaland steel engineering work.
Yes, now the respondent number 7 is the power of attorney holder of that particular work order as well. So he is executing the same respondent number 7 is executing this work also.
the lordships, item 1, 2, 3, all are work orders, allotment of work orders. And
Where the work orders? Let us see for these three.
in my,
You had filed some IA or something. Where is that?
Yes, the last on 5th of September 2023. In that lordship I have added the work orders.
5th of September 2023. 5th of September.
5th of September, yes, 5/9/2023. Annex A is the first.
Ah, got it. Yes, which are the work orders?
Annex A at page 11. lordship.
Page
11.
11.
Yes. This is for 15 kilometers. From Aken to Starlight. For an
This
amount-
is from Aken to Star Lake,
Yes, lordship.
15 kilometers.
15 kilometers.
This is given in 2011.
Yes, 11th of April 2011.
Okay, now this was the place where they had given a completion certificate in 2014.
Yes, yes.
And as of now, the physical progress is 85% and financial progress is 90%.
Yes,
You have
yes,
paid
Your
more money than the work done.
that was how the ground zero officer was, his annual increment was with,
No, this is not a case of annual income. I think we should bring in the CBI here. This is a case of CBI investigation to be given. This is a serious thing which you have done. How could we have a completion certificate of 2014 and only one person has been taken? Why will that person, Mr. AG, tell me, why will a person
yes,
give a completion certificate
yes.
and only have his for his own benefit and not for the benefit of others? Isn't it the case of money laundering?
Action was initiated against him.
Why only him? Not others? We see nowadays the ED is very busy. We can also make them busy out here in the state of Nagaland. We'll ask the CBI to investigate and
Your
submit.
lordship, work is about to be completed.
What
Now
work
it
is
is in the verge of
completed,
completion.
but how can there be a physical progress of 90%? These are works of PMJOY against centrally sponsored schemes.
Your lordship, item number 2 and 3 is non-planned
Ah.
under additional,
Then
under
so
additionality.
this is not this is state of Nagaland.
Yes, your lordship.
State of Nagaland is not how much money you have released? 90%. Work is 85%. Completion certificate given in 2014. Yes.
Now, lordship, the second work order is at page 16.
Page
16 of the same affidavit, lordship.
16.
Yes.
Page 14 is what? Or they're the
Same
same one?
copy.
Okay, page 16.
Yes, lordship.
This
The
is
second order.
allotment of work of construction Lefro to Mole.
Yes, lordship.
Okay, 26 kilometers.
For 30 crores.
Amount of the work, what is the price?
30 crores, 3,000 lakhs, lordship.
Where? These are work orders being issued. What is the price?
Lordship, it is not reflected there, but it is stated, lordship, in other documents, lordship.
Huh?
The amount is not in dispute, lordship.
Amount is not mentioned? No, it is there.
Yes.
We can in the bill of quantities to be executed.
Yes, in the
What is the total amount?
total amount is reflected there, lordship.
And these works were to be completed within 24 months.
Yes, in 24 months. At page 28 of the PIL petition, lordship. At page 28 of the PIL petition, the work amount is quoted, lordship. 3,000 lakhs.
This one?
Yes, Lordship. Now, Lordship, the work order A and work order B, they overlap each other entirely, Lordship. Work order A and work order B. Work order B is for 26 kilometers, and work order A is for 15 kilometers. Now that 15 kilometers falls entirely within the 26 kilometers. So, in other words, the second work order is only for additional 11 kilometers.
Okay. Now,
so, or in other words, for the same 26 kilometers, two work orders have been issued. One for 3,000 lakhs and other for 5 crores and 69 lakhs. Okay. Now, the respondent number 7 has admitted in his affidavit that 4.84 crores has been sanctioned to him for the first work order. And for the second work order, 26 crores, something has been already dispersed to him.
26 crores.
Yes, Lordship.
And they say that the financial progress is 90 lakhs, 90%. And the work is 90% done?
No, Lordship, because
No, as per their affidavit, which they have said.
Yes.
Let us see the affidavit of respondent number 7. Where does he say that?
Earlier also they have made similar stance.
Where is the affidavit?
Lordship, affidavit was filed on, the first affidavit was filed on 7th of April 2022, Lordship. There they have categorically stated that for the first work order, 95% of physical progress has been achieved.
Just 1 minute.
At page 12.
Of the affidavit.
Yes, Lordship. Next one.
Wait, it's very difficult to find so many.
They have
1st of November 2011,
affidavit
17 November 2021.
No, Lordship, the first affidavit that the respondent number 7 has filed. That is, I received it on 7th of April 2022, Lordship.
7th of April. Got it. Yes. What does it say?
Now, at page 3. At page 3 after the affidavit, at Roman 3, Lordship. It is stated that the last, in the middle portion, Lordship.
From Aken to Star is
Yes.
still in progress. The letter dated demand has submitted progress report on the construction of so-and-so, whereby the progress of the physical work shows 95% of the
Yes,
work has
Lordship.
been completed.
Yes, Lordship.
And today they are saying 85%.
Yes, Lordship.
Yes, Mr. AG. What is this again? Another interesting thing. In the
This is the
affidavit
latest.
filed on 6th of April by the respondent number 7, your executive engineer says that he has completed 95%. Annexure E. Annexure E. Yes. 95%. Construction of air from today, 5.69, amount release 521. This is the document, page 23, says 521.65 has been released. And the remaining is 47 lakhs, 95% completed. And what is 90% of 5.69? With calculation? You have a calculator? You have a mobile? Do that. Case for CBI inquiry.
Now, interestingly, Lordship, they have annexed in that same affidavit. Lordship, may kindly go to page 37 and 38.
Of the same affidavit?
Yes, Lordship. Memorandum of understanding with the Kamalia area public organization, that is the public organization of that area. They have executed this memorandum of understanding between the public organization and the respondent number 7, where the respondent number 7 has promised to complete the work by March 2022. Now this is already 2024.
Failing to complete the construction road from Lefroy to Mole and AKM to Milan shall take any kind of legal action against so and so proprietor, Rhino Construction. And there is a completion certificate of 2014.
Completion certificate, Lordship,
And on this document is signed when? Yes, how much it is? 521 or 569?
judges, they are working it out, Lordship. In fact, the respondent number 7 has filed another affidavit, Lordship, promising before this court that the work will be completed by June 2023, Lordship. The affidavit was filed on 3rd of August 2022.
As per the affidavit, which was filed in 2022, you have already paid him 91%. And thereupon, he has not done any more work. Mr. Joe, you have not done any more work after that in 2022?
No, the work is in progress still.
So you have done 3%. Oh, no, you have reduced it by 3%. Because earlier it was 95% done. Now we are at 85%. Yes. It has gone back.
My lord, that aspect, I'm a technician, so I.
No, it's not a question of technician. You are trying to protect your client. But how can it go down? Somebody may do work of complete and make it increase it. Only thing is the financial progress have only increased.
Now, Lordship, after the
And what
third-
is this upgradation of road from T1 to Kanchang? Nagaland Steel Works.
Yes, the third work order, Lordship, is at page 20, Annexure C of the affidavit that I have filed on 5th of September 2023. That is the first affidavit that I have shown, my lord.
Wait, again, getting your affidavit becomes a difficult thing. 5th of
The
September.
same affidavit where I have shown the 2 work orders.
Is of September.
At page 20, Annexure C.
Wait. Got it. Yes, page
20, Annexure C. The type copy is at page 21.
20. Yes.
It was issued on 21st of November 2017.
And this was to be completed within 18 months.
Yes, Lordship. 18
This is the
months.
PMJY project.
Yes, Lordship. This is for 26 crores, 72 lakhs and 77,000.
And how much amount has been paid? And have you made this that person a party, Nagaland Steel Engineering Works?
No, Lordship, the respondent number 7, he is the power of attorney holder of this particular work order. So the same respondent number 7, the proprietor of,
How do you know?
because he has admitted that in his affidavit, Lordship. By
In which affidavit?
affidavit dated 14/6/2022. The second affidavit that the respondent number 7 has filed.
14/6.
2022, Lordship.
Meet serial properly.
At page 5. Paragraph 5, page 5, Lordship.
And whose affidavit is on 22nd of February 2021? 16th of March 2022.
14/6/2022, Lordship. I received it on 14th of June 2022. An affidavit filed by the respondent number 7 at page 5. If I may read it, Lordships.
No, which affidavit?
Affidavit I received on 14th of June 2022.
Filed by whom?
Respondent number 7, Lordship. This is the second affidavit that they have filed. They have filed 4 affidavits till now, Lordship.
Hey, take out this, cut off these things. Serial properly. No, 17th of June. You're referring to which one?
Rejoinder affidavit. Filed by the respondent number 7.
Affidavit in reply to the affidavit filed by respondent number 7. It's because of these files being kept in such a manner, it's very difficult. What is the date? 6th of April.
14th of June 2022, Lordship. That is the day I received.
15th of June. Sorry. This is rejoinder to the affidavit in reply filed
Yes,
by
Lordship.
Then why you are not making it properly? You are saying that the affidavit filed, second affidavit.
Yes, rejoinder affidavit, Lordship.
Yeah.
At page 5. The top paragraph, Lordship. The respondent states that the work from 301 to Contempt, that is the third work order, was not awarded to his firm. It was awarded to MS Nagaland Steel Engineering Works. It may further be mentioned that since MS Nagaland Steel Engineering Works could not execute the work, a power of attorney was executed between them, after which the respondent began the work.
Understood. But then also,
Yes.
the respondent number 7 is doing the work on behalf of them.
Yes,
so it is
Lordship.
an internal arrangement between Nagaland Air and respondent number 7.
Yes, Lordship.
But the question is, the respondent number 7 has nothing to do with the state. Does it have?
My lord.
Unless the state has given the work to the respondent number 7.
Yes, Lordship.
It's not.
Yes.
So understood that without making Nagaland Steel Engineering Works a party, can we proceed?
Lordship, I leave that to the wisdom of his honorable court, Lordship. However, this third work order, it came to light only after the instant PIL has been filed. It came to the knowledge of the petitioners, Lordship.
How are you affected with the third work order?
Because here also, Lordship, 11 kilometers, they overlap with the work order number 2 and 3. 11 kilometers, they overlap each other, and it is being executed in the same area, Lordship. 11 kilometers, Lordship.
It overlaps.
Yes, it overlaps. Out of the second work order is for 26 kilometers, the third work order is for 38 kilometers. So the work order 2 and 3, 11 kilometers, they overlap each other. And in fact, Lordship, I have given a map, Lordship, in my affidavit.
Where? Which affidavit now?
The first affidavit, Lordship, that I have taken my lords to.
Again,
5/9/2023 at Annexure T, page 23.
5/9/2023.
The affidavit where all the work orders are annexed, Lordship.
Yes, this is the map.
Page 23, Lordship.
So this is from akin to Starlink.
Yes, the red portion is the first work order. Red area.
No, yes, that is the first order.
Yes, the green,
The second is
green is second work order.
construction of left road to Mole.
Yes, Lordship. Now, the blue area is the third work order,
So there also
11 kilometers. Now, Lordship can clearly see that the first work order and the second work order, they entirely overlap one another.
Now, have you mentioned this in your affidavit?
Yes, Lordship.
In a writ petition, or is it being brought subsequently?
In this present affidavit,
So
Lordship.
you are developing your case.
Lordship, because new facts came to light, Lordship.
So you didn't know at that point of time
No,
that
no, no.
it was overlapping.
No, I only knew that work order 1 and 2 were overlapping. I did not know about the existence of the third work order when I initially filed the PIL. And in fact, Lordship, it has further come to light that there is a fourth work order, Lordship. It was executed by another contractor, but that project has been successfully executed, Lordship. So now, in that fourth work order, 12 kilometers overlap with the work order number 2, Lordship. So now the respondent number 7 is trying to project as if the 12 kilometers overlapping portion is the work executed by him. He is trying to take credit. Now, Lordship, after 3 affidavits have been filed, Lordship, showing that, stating that 85%, 95%, whatever percentage that they have claimed to have executed, Lordship. So, since there was disputed question of facts, Lordship, a committee was constituted by this honorable court by order dated 1st November 2022. A report was submitted before this honorable court. Now, after perusing the report, Lordship, this honorable court has come to the conclusion that, as alleged by the petitioners, not much work has been done, Lordship. That is if I may kindly take my lords to the order dated 16/11/2022.
One 2022. Oh, this is the committee.
Yes.
111 is the order by
Yes.
which the committee has been constituted.
Yes, Lordship. So after perusing the committee's report, this honorable court arrived at the conclusion that, Lordship, the last page of the
Construction of the road from so and so to the work done.
of the order dated
First
16/11/2022.
Second work order, third inspection dates, so and so was Where is that again, the map? Map is where?
Page 23 of the affidavit 5/9/2023.
About the 5/9/2023. Where is it?
The first affidavit that I have taken my lords to, where all the work orders I am also annexed.
From the starting point of T1, oh, cover the distance of 19. Left to conjunct. Second work order, work order dated. This is as on, what is the date of the order? So inspection 2022. 16/11/2022.
Yes, Lordship. On that day, the committee submitted its report and this honorable court considered the report at length.
So if there is a case, from the report, it seems that there is an overlapping.
Yes, and it says
If
it's
it is an overlapping,
yes,
then isn't it the case where the state funds have been taken unnecessarily
yes,
for
Lordship,
works
exactly,
which are
Lordship.
not there?
Yes, Lordship.
Just for example, a 3-kilometer work which should have been there for from Mole Post to Starlink,
Yes,
which is outside the second.
yes. So, Lordship, these work orders, assuming that they were fully executed, even then, they may be a source of corruption, Lordship. That is the case. Assuming that they have successfully executed 100%,
Then also.
even then also, it may be a source of corruption. Because unnecessarily, they are withdrawing public funds from the state exchequer. Well, Nagaland is unlike other developed states, Lordship, or other more, let me say, economically well-off states, Lordship. Here, an amount of 100 crores is a huge amount, Lordship. Because for work orders, Lordship, it will, even assuming that there was no additional funds provided, otherwise there are also.
It is not 100 crores, it will be around 60 crores.
No, Lordship, four work orders,
26,
Lordship.
26 and
30, 26, 5, plus the fourth work order, Lordship, which
Where
was successfully
30?
executed.
No, there are 3. 26, 26 and 5.
No, Lordship, but what I'm saying is, Lordship, there is a fourth work order, which was issued for the same area, Lordship, to another contractor.
That is not before us.
Yes, Lordship.
So then why should we go into that?
Yes, Lordship, but despite that, Lordship, the fact remains that money has already been sanctioned for that also. And Lordship, additional funds, Lordship. It seems additional funds were also provided, Lordship. 15 crores at one point of time, and in the next financial year, another 15 crores has been sanctioned, which I've also annexed in my petition, Lordship.
Now, what is your relief you asking for?
Lordship, my prayer is that, Lordship, the works may kindly be overseen by this honorable court, ensuring that they are successfully completed, Lordship.
Why should this court look into those aspects as to whether the road is done or not? Yes, we are concerned.
Yes.
Why should we have a continuing mandamus?
Because, Lordship,
because what is happening on the day when you had started
yes,
the PI,
yes,
the work was completed.
yes, Lordship.
Then by the time the petition had become a bit ripe,
Yes.
then the work progress had become 95.
It's entirely false.
No. By the time now we are taking up,
Yes.
when it is ripe,
Yes.
the progress is 85. So by the time if we keep on keeping it,
Yes,
the
Lord.
work progress will one day become 0.
Yes, Lordship, exactly, Lordship. Exactly.
Then what to do?
Yes, Lordship. Lordship. Now, the fourth affidavit that they have filed, Lordship. In the fourth affidavit, they have claimed whatever progress they have claimed, Lordship. Now that has been objected to by the village councils and the Kamala area public organization, that is the public organization of that area, Lordship. I have also annexed that document, Lordship, in my last affidavit.
Now here, do you have a CID like we have in Nagaland? Yes, AAG. What do you have? Should we give it to the CID or CBI?
Your Lordship, although it is not stated,
Because it
Due
is
to-
from the report which have been given by the commissioners, it is apparent that there is an overlapping.
due to issuance of the completion certificate, we have taken action
No, you have
against the
taken
ground zero
action,
officer,
but how? What are you going to do?
and the work is still in progress.
No, why can they? Why the? In spite of the fact that it is overlapping, also it is not in progress. It has not been completed.
Sometimes due to natural calamities, the land entire stretch
Mr. Counsel,
wash away.
I hope I'm.
And then
being able-
another,
No, Mr. Counsel, I hope I'm able to make you understand. It is a case, forget about the completion of the work or how much progress it is. It is a case that these engineers or whoever has done that had given, conferred, or issued tenders in respect of overlapping works. And if it is overlapping of works, are you not for a particular portion, just for example, a person would have been given 12 kilometers, of which 9 kilometers is already done in another contract. And that is the report of the commissioners appointed by this court. How do you take care of that situation? And then also, in spite of the report of 2022, you are continuing to make payments.
your lordships, as instructed, I place before this honorable court, what is the progress and status of the.
Understood, but how do you take care of this situation where there is overlapping on the face of it? This is the report, that there is a report of 12 kilometers, which, see the report, category 3, where there is an overlapping. It says, second work order 2011-2000 for overlaps first work order of so-and-so Iman, earthwork for stretch of 12 kilometers, side drain for 12 kilometers, 8 numbers of huge pipes. This is being overlapping. The third work order again overlaps with the first and second. That means yes.
Lordship, whatever materials, instructions made available, accordingly I filed this.
No, understood.
petition.
No, understood. I have seen that. But what is, how do you take care of this situation?
Your lordship,
On the face of it, there is an overlapping.
the record is very clear. Although the allotment of work order was issued as early as 11/4/2011, yet the fact remains that the sanction was recorded only in 2017 and 2018 without allocation of fund. This contractor had been executing and he had
Till
been
6 years, from 2018 also not complete.
due to various reasons. Your lordship may be very aware about the
How
situation.
can there be a non-completion for,
And the
you have issued the work order for 3 years or the 18 months. How could it be going on for 6 years? I'm not,
constant,
Mr. AG, I'm not concerned with other things, but
Your
how can there be an overlapping? Overlapping means in respect to the same contract, you are giving 2 persons
your
the same thing.
lordship, if I may be allowed to highlight,
Hmm.
as the respondent authorities, we have no knowledge whether or not it is overlapping. As of today, we don't have any idea. We don't
In
have any,
spite
knowledge.
of the order which has been passed by this court,
No overlapping, your lordship.
in spite of the commissioners making a report, have you challenged the commissioner's report? Have you challenged this order before the Supreme Court? No. So under such circumstances, we are to believe on the basis of the records. The court has duly believed this.
So
And
far
this
as-
happened in the year 2022. Till now, no work has been completed. That is a different aspect, but how can there be an overlapping? It is a finding of fact derived by the commissioners.
Now the work is on the verge of completion. The lordship may be pleased to grant specific time so that the work can be completed.
That can be done. There's no
Yes,
problem with that. But only one work is PMJY, GSY.
Your lordship, it is not in the name of the present contractor.
So that we are
this
not
is not-
concerned.
It's a
Because
non-jointer.
because Mr. Joe had produced one document on the last occasion, which was in respect of PMJ, GSY. But the other 2 contracts are non-planned.
If that be the case, your lordship may be pleased to pass any effective order to implement the
No, we are not concerned with number 1. We are concerned
other
with
contractor
The
who
other
is
two,
not
for the
implicated in this
purpose of,
case.
you have a CID?
No.
Oh, the only thing is the CBI. Yes, Mr. Yangavati. Yes. CBI.
Lordship, if I may be allowed to.
Who appears for the CBI? You have a CBI counsel?
Lordship, if I may be allowed to.
What is this? This is only sent to the Ministry of Mott.
Yes, Lordship. Since we don't have any instruction from the ministry, we are.
No, we are
unable
not
to-
concerned with Mott. We are concerned with CBI. We come in 10 minutes.
Where is it? You have any other copy? Seven 12, 7 12, 22. This was read by. Actually, is also. Without. We have filed affidavit on January. Night affidavit. Actually,
in the month of January, by respondent number 4, month of 2023, filed by the respondent number 4, Chief Engineer PWD and as directed by the Son of Gordon, and the this is the observation of the committee, but however, we have applied. But that's just an observation. Given that. The month of January.
अच्छा प्रगत
18 January. 18 January.
Your Lordships, if I may be allowed to refer back to my affidavit,
Which one?
which was filed on 18 January 2023, whereby the respondent authorities had stated that there is no overlapping.
18th of January.
18 January 2023, Your Lordship.
Yes.
Page 4, Your Lordship. May I read, Your Lordship? Report on overlapping portion. Observation of the committee. 6A. Second work order dated 2011, Lepore to Molhepukian overlaps first work order dated 11/4/2011, akin to Starlag for the following items of work. Number 1, earthwork for a stretch of 12 kilometers overlaps from Aken to Molhepos. 2, side train for a stretch of 12 kilometers overlaps from Aken to Molhepos. 3, 8 numbers of Hume pipe overlaps from Aken to Molhepos. Reply by department on 6A. There is no overlapping during the actual execution because 1, in the second work order, Lepore to Molhepos, the approved road land is only 26 kilometers. However, the actual land from Lepore to Molhe is 36.5 kilometers, including 2.5 kilometer land required for gradient correction on Akendu Molhe section of the road. As such, under the second work order, actual work carried out from the Lepore to Aken is 22 kilometers and 4 kilometers beyond Aken only. Total land is 26 kilometers and not up to Molhe, which is 10.5 kilometers far away. Contractor has done much beyond. 2, under first work order, Aken to Starlag, work order land is 15 kilometers only. However, actual land from Aken to Starlag is 19 kilometers. As under Aken to Molhepos, 14.5 kilometers, Molhepos to Starlag, 4.5 kilometers. That is extra work, comes to 19 kilometers. The actual work of first work order started from 4 kilometers beyond Aken up to Starlag, which is of land 15 kilometers. Work order land, Lepore to Molhepos, 26 kilometers, but actual work was done up to 36.5 kilometers. Aken to Starlag, 15 kilometers, but actual work was done up to 19 kilometers. Total land, 41 kilometers. Actual land is 55.5 kilometers. Total actual land from Lepore to Starlag is Lepore to Molhepos, 36.5 kilometers. Molhepos to Starlag, 4.550 kilometers. That is total 41 kilometers. Page 6, Your Worship. Actual work executed length. Lepore to 4 kilometers beyond Aken, 26 kilometers. 4 kilometers from Aken to Starlag, 15 kilometers, total length 41 kilometers. If we go according to the nomenclature of the first and second work order, there appears to be overlapping portion from Aken to Molhepos, 12 kilometers, actual length 14.550 kilometers. However, on actual ground, there is no overlap as to the total length of the first and second work order. 15 plus 26, that is 41 kilometers, is exactly satisfied by the actual length between Lepore to Starlag. So there is no overlapping in ownerships. Rather, the contractor has done much beyond the permitted work order in the interest of the public. That's all.
The statement, Lordship, unfortunately, is totally false, Lordship. And the state respondents, Lordship, they have tried to mislead this honorable court. In fact, all the respondents, Lordship, since the day this BIL has been filed. In fact, their previous affidavits were belied by the report submitted before this honorable court by the committee appointed by this honorable court. Now also, Lordship, without doing anything on the ground, they are placing documents after documents before this honorable court, which are all false documents, Lordship. False completion certificates, false status reports have been placed before this honorable court. I don't know how, from where they get so bold to mislead this honorable court. Perhaps they are thinking that since they are placed in remote parts of Nagaland, the arms of law shall not reach them. In fact, Lordships, at Annexure 7 and 8 of my BIL petition, Lordships, I have enclosed two documents which shows 15 crores additional fund being sanctioned, additional fund, Lordship, against the second work order. One was sanctioned in the year 2017, Lordship, during the financial year 2016 to 17. Another was sanctioned in the year 2018, during the financial year 2018 to 19. So in total, 30 crores of additional fund has also been sanctioned against the second work order, Lordship. At the cost of repetition, Lordship, the village councils and the public organization of that area have also issued a certificate which I have placed before this honorable court by way of an affidavit that I have filed on 21st of February 2024, Lordship, categorically denying the status report and submitted by the respondents before this honorable court. If my lord, kindly go to page 34, Annexure H of the affidavit, the last affidavit that I have filed on 21st of February 2024. This is an affidavit in reply to the affidavit to the counter affidavit filed by the respondents. Respondent number 7. Page 34. Page 34. Annexure H of the affidavit that I filed on 21st of February 2024. The last affidavit that I filed. Affidavit in reply to the counter affidavit filed by the respondent number 7 at page 34. Now this certificate, Lordship, has been signed by the President as well as the General Secretary of the Kamala Area Public Organization, as well as all the 5 village councils, Lordship, the chairman of the 5 village councils. They have denied, Lordship, the work progress certificate issued by the executive engineer, PWD Road and Bridges, Tech Division.
Yes, Mr. AG, kindly come to page 34 of that affidavit which you are reading.
Yes, my lords.
Construction of the road from Lefroy to Mohole Post. You got it?
Yes, ma'am.
26 kilometers. Amount, sanction amount is 3,000. Work order amount is 3,000. Then released 3,000. There will be a deduction of tax 345. Total is 2654.88.
Yes, my lords.
How much amount has been released? Is the total amount has been released 2654.88. Okay.
Yes, my lords.
So this was done as on the on the month of January 2023.
Yes, my lords.
Now kindly see the affidavit filed today. In respect to the same contract,
Yes, my lord.
you are saying the financial progress is 90% when the entire amount has been released?
My lords, time to time, the ground zero officers, at the same time, head of the department keep changing due to retirement or otherwise. So this is the latest which I have received as on 22nd
So then
February
here,
2024.
a person could not have released, this is an affidavit filed by the chief engineer, wherein he categorically says that the entire amount has been paid to the respondent number 7. This is page 34. Whereas today's document shows that only 90% physical progress.
Yes,
How is
sir.
it possible? On
Yes,
the
sir.
face of it, Mr. Counsel, this doesn't inspire the confidence of this court. The question is how to tackle this situation and how,
Yes, ma'am.
who should be the investigating authority? Should we give it to the CBI or we should constitute an SIT and then submit a report before this court?
Your lordship,
This is a serious thing which you have done. On the face of it, it looks, yeah.
although your lordships, nothing stated here, but due to natural calamities.
Natural calamities, the question is that on to the January 2023, the payment is total amount has been paid. And today you are saying that it is not. Something is wrong, seriously. On the face of it, there is a mistake. I think because of filing too many pleadings, you must have done this mistake. Every time. Earlier it was said that this particular first work order, 100% complete. Then you come up 95%. Now you are coming up at 85%. As regards the second work order, in January, you say that the amount entire amount has been paid. And what is the progress? Kindly see in this affidavit from the construction road from Lefroy to Mohole Camp, your physical progress at page number 8 is 46.34. Kindly see from that affidavit itself. And you have paid the entire amount. How is it possible? Either the chief engineer must have, on the face of it, there is a mistake. Kindly see page 8 of that affidavit and page 31 of that document itself. This is the work. We are concerned with this one, the other one, page 33, status of the work progress. Overall physical amount is, physical progress is 46.34. And the payment made, kindly see that the entire thing, the payment has been made 34. The entire amount has been paid, up to date payment. How is it possible? Yes. Yes, Mr. Joe, what is your submission?
My lord, he has finished. Yes.
Yeah, they are finished.
May I please, Lord? My Lord, the other day, I have make a humble submission that I have raised preliminary objection by affidavit. Now, if we look at the prayer of the repetition, merit is different. In the prayer of the repetition, there is only one prayer, questioning only one work order. Now, by placing certain document before the court, filing affidavit, whether they can improve the petition 101, that is on merit. Because as per the repetition, they have made a specific prayer only in respect of the work order Lepori to Molhe. No other work order has been talked about it. Now, affidavit after affidavit, they have filed producing all the other work orders, whatever it may be, which is no subject matter of the repetition in the initially. That is one aspect. Later on, that is another issue. Now, since this being the PI, the first question before this honorable court to determine is whether this petition is maintainable in the face of the PI, public interest litigation. My Lord, I have filed. Lordship may kindly come to my affidavit where I have raised petition. Counter affidavit filed by respondent number 7. On 10/10/2023, filed by respondent number 7.
In 10/2000.
Yes. Counter affidavit filed against the additional affidavit filed by the petitioner on 14/8/2023.
No, your affidavit
Yeah,
filed
my
by
affidavit.
respondent number
Counter
1 to 4.
7 is 10/10/2023. The other day also what we have. Because in my humble submission, in the case of PIL, the first question before the honorable court is to decide whether the petition is really maintainable or not. Only after that, it will come on the question of merit. Lordship,
Yes, got it.
Merit. My Lord, straight I'll come to page 2, my Lord. May I read it, my Lord? Paragraph 1. That at the outset, the deponent before answering the advertisement wishes to raise an objection on maintainability of the present public interest litigation on facts as well as on law. 1A. That the present public interest litigation is not maintainable in its present form. 1B. That as stated in the paragraph number 1 of the public interest litigation petition, the petitioner number 1 has been authorized by the petitioners number 2 to 4, and in support of that plea, an authorization later dated 31/8/2020 has been annexed as Annexure 1 to the public interest litigation. Such authorization is not permissible in public interest litigation petition. 1C. That in the same authorization later dated 31/8/2020, significantly the statements inter alia made it quote, do hereby authorize Sri Kezuwete Reza, son of so-and-so, permanent resident of Chidami village, district Pet, state Nagaland, to put his signature in the public interest litigation petition on our behalf in complaint in respect to road construction from Lepori to Molhe Camp. That is so-and-so, and akin to Star Lake 15-kilometer underpack division PWD, unquote. By no stretch of imagination, such authorizing someone, that too in a public interest litigation petition is maintainable. 1D. That the public interest litigation petition has been filed without complying with the requirements as laid down in Gauhati High Court Public Interest Litigation Rules 2011, more particularly Rule 10. 1E. that it is also relevant to point out herein that the Government of India, Ministry of Rural Development, Department of Rural Development, right, letter number so dated 8 June 23, addressed to all the states and union territories, authorities has extended the timeline of all contracts under PM 1 and 2 till March 24. In that view of the matter, all the allegations leveled against the prior response number 7 made in the present public interest litigation are baseless and premature. 1F, in my case, 1E, no, 1D and 1F is correct. 1G, 1F, that on the face of it, the public interest litigation petition is not maintainable on the averments made and the grounds assigned therein. The subject matter in the present case being out and out of contractual matter by and between private respondent 7 and the official respondents. The petitioner cannot intrude upon the same on false and frivolous grounds. 1G, this is relevant in my case. It will be relevant to mention here that the petition number 1, 3, Kezuwete Weza.
Mr. Joe, just 1 minute, huh? Yes, Mr. AG, kindly come to one thing. Kindly see that very affidavit which Mr. Joe is reading.
Yes, ma'am.
Kindly come to annexure R2. Page 9. Now you can see it from Mr. Joe.
But this is R.
You see, on 9th of September 2023, this very officer, the executive engineer PWD RNB, signature appears to be the same, says that on 9th of September 2023, the physical progress is 90% for this work. Okay?
Yes.
Today, you are enclosing a document where he says that physical progress is 85%. See, the same person will sign this. How is it possible?
One G.
Yes.
May I repeat, continue?
Yes.
That it will be relevant to mention here that the petition number 1, namely Kewezute Weza, and petition number 2, Srimati Yolongla, personally visited Srimati Vono, who is the cousin sister of Progress number 7 at 9:20 a.m. on 29th July 21 at her private residence, Northern Angami Colony, Welfare, Dimapur, Nagaland, demanding financial favor amounting to 65 lakhs from private number 7 contractor and threatened to file public interest litigation. The petitioners have filed the instant public interest litigation because of refusal of the respondent 7 to get to the illegal demands. Necessary evidence, including voice recording in this regard, shall be produced even when required. 1H. That at the early stage of this case, the private number 7 was at a loss and apprehensive about it, disclosing the said act of financial demand by the petition number 1 and 2 on behalf of all the 4 petitioners. But now, after having considered such illegal demand, the private number 7 has mustered courage to disclose the same before the number 4. 1I. That the instant public interest litigation petition is not filed in public interest, but purely for personal gain or private profit by demanding a huge amount of 65 lakhs from the contractor, private number 7. 1J. That all the above facts would lead to only one conclusion, which is the initial public interest litigation by the petitioner is a frivolous petition initiated by the petitioner 1 and 4.
So, Mr. Joe, you mean to say
Yes.
that the cousin sister, the petition number 1 and 2 went to the cousin sister of the private response number 7
Correct.
at 9:20 AM on
Yes.
29/7/2021
Yes.
to say that he is going to file a PI.
Yes. Voice recording also there.
Very well.
Yes.
But the PIL was filed on 10th of November 2020.
Correct.
And he goes out there to tell that we are going to file a PIL.
Even before that, yes.
Then how do you take care of that situation on the face of it when the PIL already filed on 10th of November 2020? So if we take this also, it doesn't show because that person concerned goes to some cousin, that too in the year 2021, the month of July, and says that I'm going to file a PIL. And why didn't you raise this in your initial affidavit?
Exactly.
Yes.
Lordship, that time, yes, I'm sorry, I was engaged at this stage, later part. It was in fact handled by another lawyer who is little young. Yes. So after they have replaced me. They have replaced that gentleman and I have come in now at the final stage. That is, I'm so sorry about
No, why I'm saying
Yes.
other aspect is okay.
Yes.
This allegation
Yes.
could have been very well put in
Very
that
much,
affidavit.
Very much. That's why.
All other aspects is different thing.
Correct.
These are questions of law. But if it is a question of
I
fact,
agree.
that should have been brought to the first of a
Correct,
proceeding.
correct, that part. As I said, initially I was not there. Yes. Only at the final stage I had come in. Yes. Now, my lord, I have raised this. Now I'll read out what the High Court rule says about filing public proceedings. Whether this is really maintainable or not. The objection that I have raised.
Hey, there is a new book. Yes.
Gauhati High Court. Notification 27 January 2011. My lord, we have just applied the copy because that is a separate rules, my lord. Yes, separate rules.
These rules are here, no? Public interest 488.
Yes, 2011.
Yes.
My lord. Now, what the rule says, what rules has been prescribed, whether the present public interest litigation has been filed as part of the May I read it, my lord?
Yes, please. You are referring to Rule 10.
Rule, before that, my lord, before. I'll just show lordship. Just first, in exercise of powers conferred by Articles 2 to 5 of the Constitution of India, and all other powers enabling it, and in accordance with the order dated 18/1/2010 of the Supreme Court in Civil Appeal Number so titled State of Uttaranchal versus Sri Balwant Singh Chawla. The Gauhati High Court hereby makes the following rules with respect to practice and procedure for the exercise of jurisdiction under Article 2 to 6 of the Constitution of India pertaining to public interest litigation. Now, part 1 is not relevant in our present case today. Part 1 is about the suo motu. Part 1 is about the definition, rules, all this matter. Part 2 is suo motu, letter petition, my lord. Now, part 3. Part 3 is the relevant portion for today. Part 3, filing of public interest litigations. Rule 10, instruction for filing public interest litigation. I read 1, Rule 10, clause 1. A writ petition intended to be a public interest litigation shall, the word shall is mandatory, shall, I want to emphasize this, shall contain an inscription immediately below the number of the writ petition in the title, namely, within invert.
What do you say about Rule 11? No, forget about Rule 10. Rule 11. Now come to Rule 11. That is where, without that rule, you are arguing.
No. My lord, Rule 10.
After that, Rule 10, Rule 11. It says, notwithstanding anything contained in these rules relating to the procedure for filing and entertaining any repetition in the nature of public interest litigation, the High Court may suo motu decide to treat any matter or issue as a public interest without insisting on the adherence to the said procedure. So, how is it relevant? On the face of it, it shows that there is some illegalities out here.
No, I'll just allow me to finish. I'll satisfy lordship. Rule 10B, Rule 10B, because the Rule 10 is mandatory according to interpretation judgment. I'll show you.
No, you are referring to the judgment of Justice Dhulia.
Even this High Court.
Show me that.
I'll show.
No, I've seen that rule that day, yesterday. You should show me the judgment wherein it says that Rule 11 is not to be denuded or without compliance with Rule 10.
Yes.
Without this court is denuded of the power.
Very much. This is 2007 our own High Court. Justice L. Jamir and Justice Sarko.
Yes.
2017 volume 2. Union Bench judgment. It's a short judgment and with similar, almost similar. Factually similar. Relevant page is my lord, page 443, but relevant page is paragraph 3, page 444. May I read it? Short factual, so that I wanted to read it. Paragraph 3. At the outset, Mr. Jimomi, Learned Counsel, who appears on behalf of the respondent number 1, 2, and 3 in public interest litigation number 9 of 2015, raised a preliminary objection on behalf of the respondent by stating that the petitioner has not complied with the requirement of Rule 10G. G will talk about that first you must make a representation to the authorities of the Gauhati High Court rules, public interest litigation rule 2011. And since this rule was framed under the direction of the Honorable Supreme Court, it is mandatory in nature. Therefore, the PL has to be dismissed for non-compliance of the said rule. Similarly, Mr. M. Mujui, Learned Counsel, who appear on behalf of respondent number 4 in all the PIL, except in PL number so also raise same criminal objection, preliminary issue, and pray for dismissal of all the PIL on the ground on that ground. So. Now I'm come to paragraph 4, the finding of disorder. Before we come to the exact point of objection raised by the Learned Counsel for the respondents, we would like to lay down here the background as to how the rule under which the objection has been raised originated. But before that, it may be worthwhile to briefly state how public interest litigation has evolved.
Mr. Joe, that judgment does not deal with Rule 11, 1. And secondly, the judgment further gives the authority liberty to approach again by compliance with Rule 10. But Rule 11 was not taken into consideration. So, anyways,
yes.
Then
I'll come by same judgment. The relevant paragraph are
which one?
Same judgment.
Same judgment.
I'll just read so that it will make it clear. Paragraph 6, 7, and 8. Following the directions of the Honorable Supreme Court, reasonable court exercise of the power conferred under Article 225 of the Constitution of India has made the rule called Gauhati High Court Rule, Gauhati High Court Public Interest Litigation Rule 2011, and under Part 3, Rule 10 of the said rule, instruction for filing public interest litigation has been provided. At clause G of the Rule 10 of the said rule, it is provided as follows. G clause invert or within invert G. In para 6 of the writ petition, details of the representations made by the authorities concerned for remedial action and replies, if any, received thereto shall be set out precisely. Unquote. According to this rule, it is obligatory for the petitioner of a PIL to give us or submit representation or memorandum to the authority concerned before the PIL is filed in order to give the authority the opportunity to perform its duty. It would be seen in the above stated rule that the word shall is used. In normal interpretation of laws, statutes, rules, the word shall is generally accepted to connote mandatory nature of such rules or law. Therefore, the above stated rule has to be followed as it is written. But then I'll skip the rest, then I'll come to paragraph 7, my lord. We have perused all the PILs laid before us, and we have found that in none of the petitions, the petitioners having discharged their statutory obligation as contained in Rule 10G of the Gauhati High Court Public Interest Rule 2011, which is mandatory. Therefore, we are unable to admit the petitions for the reasons. 8. However, before we part with this order, we would like to record our observations as follows. This batch of PILs, in our view, possess a beneficent potency beyond the individual or individuals who has filed them. Therefore, we have viewed them with all seriousness and concern. Therefore, further, realizing that the courts in our country have admitted PIL by broadening the base of the concept of locus standi, considering the situation in our country that the masses in many senses are weak and therefore unable to fight for themselves for justice, we have tried to discharge our constitutional obligation by broadening the base of locus standi. We have also taken note of the sad reality starting at us today. That is, the poor masses are unable to come to the courts for redressal of their grievances. Therefore, they have started losing hope that changes can be brought about through our justice delivery system. With that in our mind, we have tried to discharge our constitutional.
Mr. Joe,
Mr.
Mr. Joe,
Yes,
we have read the judgment, completed.
yes.
Yes, now come to the next point, the next judgment.
Next judgment. My lord, this is the division bench judgment of Katak Court. Just 1-2 paragraph.
What is the citation?
This is the sources from Indian Canon. I could not get it from that. Paragraph 4. Presided by Acting Chief Justice and another judgment. Paragraph 4. On the same issue, in course of hearing, when this court make a query as to whether the petitioner has complied with the Orissa High Court Public Interest Litigation Rule 2010 or not, learned counsel appearing for the petitioner failed to answer this thing. Therefore, this court is not inclined to entertain this writ petition, as the petitioner has not adhered to the Orissa High Court Public Interest Rule 2010. Accordingly, the writ petition stands dismissed with cost of 20,000, which shall be deposited in the welfare solution. Then, my lord, the next judgment is High Court of Allahabad.
Mr. Joe, we are not bound by those judgments. We are not bound by the judgments of the Allahabad High Court or even the Orissa High Court. Yes, you show us judgments which are, yes, persuasive value those judgments have. That has to be on the basis of what rules are there and why it should not be. Yes. You see, the judgment of the coordinate bench out here does not deal with Rule 11, which grants us the power or which still retains the power of this court. Taking into account that the court have already taken note of that, in spite of your preliminary objections raised, the court have been proceeding, asking you to file. On the face of it, it shows that various documents are contradictory. The state is coming every time with a different thing. The same officer in January 2023 says that this person has completed 90%, and today in 2024 says that the same officer says that it is 85%. The same, you kindly see out here, the state government, there is a serious allegation of overlapping. He says no. And on one hand, he says 46% has been done as on January 2023, but the entire amount has been released. How is it possible? Doesn't it strike at the conscience of this court on the face of it? So irrespective of all these things, Rule 10 and all, the power is still reserved with us under Rule 11. We still continue. And you see, kindly see, these are all instructions to file. The power under Article 226 cannot be controlled by the rules. These are self-restraints. We may, in our discretion, take into account this, we may not. But the question is, does this PILs shocks the judicial conscience of this court? Taking into account that the state who is filing an affidavit on the face of it is making false statements or right, left, and center.
My lord, as far as marriage is concerned.
You come up with a statement out here that this person concerned, petition number 1 and 2 goes to your cousin out there in 2021, July, and says, then look here, if you don't pay me 65 lakhs of rupees, I will go and file a PIL. Whereas in the month of November 2020, the PIL has already been filed. What is all these things?
As far as merit of the case is concerned, like I said, I'll dwell on that. As always, I'll start from the right of the petition.
In fact, when the matter has been pending, the best of course of the events would have been that the petitioner completes the respondent number 7 ought to have completed the work and say it before this court, look here, we have completed this. We have not taken any further amount to that. That should have been your thing. But you have not done that. What you are asking, that this PIL needs to be dismissed on this ground, but on the face of it, it looks awful.
My lord, the word as they have filed on the court.
You are relying upon the PMGSY, whereas those two works, work number 1 and 2, doesn't relate to PMGSY. These are on non-sanctioned budget plans. Then on the face of it, they say, and how are you relying on this and saying that it has become infructuous or premature?
I know, my lord, I'll submit my submission that has to my lord that this is I leave it. Now the judgment, I'll just cite similar principle. This is from the Allahabad High Court.
Mr. Joe, if you continue to submit on these Allahabad High Court and all these judgments of these, more particularly the Orissa High Court and here, which does not lay down the law, it is on those facts it has been stated outside, then it kindly show a judgment which would change our opinion, saying that irrespective of Rule 11, then also, if 10 is not being complied, you don't have the power. Show me that. Show me that judgment. Then only this will happen. Because we have also taken note of the Balwan judgment of the Supreme Court. It does not say, it says the High Court will frame rules. In fact, recently we were taking up, you must have seen it, we are having a full bench of Justice Michael Jotankumar, the Justice Kalyan Surana and me, on the question of whether subsection 3 of sub-article 3 of section 200, article 226 can be said to be mandatory or directory, because the power under 226 is unbridled. If it is unbridled out there, can by any provision, because judicial review power is a basic feature. In fact, if you see the Constitution bench the hearing which has been going on in the Supreme Court, in the cases, in the matter which has been referred to the Constitution bench in the case of Asia resurfacing, where there was a direction passed by the Supreme Court to the effect that every 6 months, if it is an order is passed within 6 months and there is a stay, if 6 months nothing, the order is not being enlarged or by reasons, then the stay which has been given in the trial court proceedings automatically stands vacated. The Supreme Court was of the opinion, as could be seen, that this is a power. Can it be done automatically without any recourse to any law? So under such circumstances, you are therefore to show us that we have a power under Article 226. You cannot exercise in view of Section Rule 10. Show me some judge precedent on that. And Rule 11 does not gives you any power to relax. These judgments are not. Neither the judgment of the coordinate bench authored by Justice Serto, neither the Katak High Court says anything about that. I would have understood, Mr. Joe, on the first day or second day, whenever you had appeared, you have raised this objection and the court says that, okay, we are not going to entertain this. Throws out the PR. But we are at a stage where there are orders passed by this court in exercise under 226 directing appointment of a commission. The commission reports is included in the order. After that, this court had formed the prima facie opinion and directed the chief engineer as to when these works will be completed. When this court have already reached a stage after 4 years, after taking in this matter on daily basis out there or whatever may be basis, and then can this court today say, look here, whatever the court spent all this time was unnecessary, let's throw out this repetition. What you did have said, Mr. Joe, if you were on this side? Understood, you are protecting the interest of the respondent number 7. But being a counsel, an officer of the court, what would you say? Very difficult. Otherwise, I will not. But you see, the court have exercised the jurisdiction all this while. At the first instance, it's a different thing. I would have understood. We are raising the question of it's a contractual dispute. Yeah, very well. It's a contractual dispute between respondent number 7 and the state. But the question is, if there is a question of overlapping, the question is, why the work has not been completed? The question is, how in a work of 2011, the completion certificate was given in 2014, and thereafter in 2000, as of now also, in 2024, 85% has been done.
My lord, I'm compliant.
How do you take care of these situations? Will come at 2 o'clock.
Yes, so questions and then the question relations.
Online. There are judgment. In the reach. There is only one. What about that? That's one line. But you can find this one. Hello? Hello? Yes. Yeah, what is it? I will report now.
We come to either. Yeah,
नहीं नाउ तो हमने लगाना इधर लगा दो Hello, Mr. Jesse. Mike is good. Tay halai dia tu. Osor tay rakhi dia lebih ni dakai mina kusi beli tu gitu. Bar council per kobo ko ada. Bar council per kobo ko ada. The other day, I was talking with the president. So players can be good by. Kami can be let good out good by because we cannot do any other more down there.
To mention item number 14 and 15 also. It's not, not next week. 14 and 15 also.
When do you want? When do you want it?
Next week, Lordship.
The request of Ms. M. Mary
Yes, John.
as appearing on behalf of the respondent.
Lordship.
Matter stands adjourned to be listed again next week.
Lordship, similar prayer for item number 16 to 24.
Don't take that liberty. One, you mentioned about this in the morning. That is why I'm considering it. Again, with two being given, again another two you are asking. No.
In the WA3, there's the interim. In WA3. In readable 3, there's an interim. I think that's what mentioned to. I think let the interim continue, Lordship.
Item number
Item is 15, Lordship.
33.
14.
14 will take it up.
No, 14 has been mentioned just now.
Okay.
So that item, there's an interim.
Item number 3, that item.
Okay.
List the matter next week on, we'll have it on 6th of March.
Lordship.
Interim order passed earlier shall continue till then.
Like one.
Yes, where is Mr. Joe? Now, what are you asking for? What is the relief you are asking for?
For the construction of the road, Lordship.
That they will do it, don't worry. Then,
Lordship has rightly pointed out, Lordship, SID or it may be given to an independent inquiry investigative agency, Lordship.
SIT, what do you propose? In an SIT, what do you propose?
SID or commission headed by a retired judge. There is a possibility for it.
Yes, Mr. Joe. Anything else?
My lord, yes, I have raised an objection. As far as the merit of the case is concerned, today, in fact, actually, prayer, his lordship see a prayer of the writ petition, prayer. PIM. Page 19. There are only 2 prayers. One is only compliant. Page 19, my lord.
One is not compliant.
One is only this honorable court. The prayer of this the prayer of the
No, not
petitioner-
that. That company, that is a commission given only to look into that. To inquire and then submit a report is a different thing, which has to be done by a SIT, special investigative team.
My lord, next prayer. That prayer is inquiry, not commission, inquiry committee. The prayer inquiry committee be ordered. That's one. Next, we are answerable on next 2 prayer. Prayer number 2. Direct the respondent for construction and maintenance of good proper works for from Lepuri to Molhead. Only this work order is in question. And therefore, that as far as that work order is concerned, I'm about to finish. I may be given time to finish. That's simple as that. Facts, I cannot, because
Now, Mr. Joe, we are not only limited to one work order. You also, being a seasoned counsel, know that in a public interest litigation, the rules of technicality does not arise. When the matter is before the court out here and you see that there are 3 work orders, and in pursuant to these 3 orders, these have been done. In fact, in your affidavit which you have filed, you have categorically, otherwise I would have thought of making that person a party. But in your affidavit which you filed and took us, there, more particularly the affidavit filed in the month of the small one, na? Where is that affidavit? Yes, in this affidavit filed on 21st of July, you have dealt with all the 3 things, 3 projects all along. And this counter affidavit, respond number 7, you categorically say that these are the 3 work orders which have been given to you. Kindly see paragraph number 4 of the affidavit filed on 10th of October 2023. The deponent does not deny to the fact that the 3 work orders dated so and so, so and so, so and so have been awarded to him.
My lord, I agree. The only simple argument submission is this. When that is not the subject matter of the PI prayer, my lord, my humble submission. Now, as far as the present PI, it's only concerned with 1 work order. And without amendment of the writ petition, whether it is normal court will the jurisdiction and without amendment. When the subject matter, when the
Mr. Joe, you are clear on this. The law is very clear. The rules of technicality does not apply in PIs. That is the law.
in my humble submission,
This submission would have, you see the reason why. This court has taken into account now the 3 work orders are before this court. There has been pleading get changed. You have replied. You didn't say that all these aspects.
the only burden I have, whether the court can travel beyond the prayer, because the prayers, as we have seen, only 2 prayers now. One confined to 1 work order and one is include committee.
And then that is not a problem.
Unless the other work orders are before this noble court.
All other work orders are glaringly before this court.
When there is no prayer made in the PI.
Not necessary. It is a these are technical rules of technicality does not apply. Many judgments from SP Gupta onwards, judgments categorically say the rules of technicalities does not apply. You see, first and foremost, he has to come in public interest. If he has come in public interest and the court is in session of the matter, then the court can very well take many other aspects because it's a PI jurisdiction. Unlike a writ, where the person aggrieved concern is a different aspect. So under such circumstances, what should be the order passed? This matter will remain pending, don't worry, but something has some word.
That's what my submission is.
That those have been duly noted, but the thing is, what is the order to be passed out here as regards an appointment of a SIT, or for the purpose that the matter needs to be referred to the CBI? CBI would be better. What do you say?
My lord, see the work is from the nature of completion. Nothing much now. Because as Bhavana said, the work is.
But Mr. Joe, kindly understand, what the state have done is pinpointed only one executive engineer. Okay, that is one. The pinpointing of the executive engineer is only to the effect that he has been done, but for whose benefit he has done, the state has not done anything. The same engineer who has filed the affidavit today, who has given the certificate, has given a completely different certificate earlier. Then nothing has been done. Can it now be said that the state is, isn't it the case where this court has been taken for a ride by the state authorities? Maybe at whose behest I'm not saying. But the state authorities have taken this court for a ride because every time an affidavit is filed, normally you see a progress, it is coming down. Initially in 2014, it is completed. And thereafter, the moment it keeps on, if the matter finishes of another 10 years, there is no work, zero.
It cannot happen like that, my lord. It cannot happen like that. My lord, in my humble submission, lordship is right. Common version completion. So therefore,
Look, how can we understand that it is in the verge of completion? How can we understand that or take into account that? Because it was stated by the state respondent that 95% has been completed. And now we are seeing the same work as completed is 85%. How do you take care of that situation? During the pendency of the writ petition of a PIL, you should have completed, called the petitioner out there for inauguration. That would have been better aspect. We'll do one thing. We'll take it up tomorrow. Tomorrow I'm taking it up. There's another matter. We'll pass the order in your presence. Let me have a think what to be done.
Please, my lords, tomorrow I may be allowed to make a short reply to you.
What?
A short reply to the tomorrow, lordship. I may be allowed to
Make a what?
short reply to the submissions made by the letter.
Don't spoil your case. We are in your favor. Yes.
Oblige, my lords.
Just put it in serial. Yeah? It's the matter tomorrow for further hearing. And your affidavit have not been taken, have been accepted or not? There was a problem in accepting your affidavit.
Not yet.
Huh?
It was brought here without registration.
This is the matter tomorrow. Mr. So-and-so, the learned AG submits that in compliance to the earlier order dated 21/2/2024, the state respondents have filed an additional affidavit. However, the registry has not accepted the same on account of certain defects. Taking into account the above, this court directs the registry to accept the said affidavit and bring it on record. But bring it on record. No, tomorrow. You were not supposed to be here. I actually fixed this matter for your hearing tomorrow. You were supposed to be in some Mokokchung area for the purpose of yes. Oh, okay. Then, so you were supposed to be. Therefore, I am relieving you now.
Because of this, lordship was insisting that I have sent my junior there. The murder case trial there.
So it depends on the choice now.
No, today, the case is today.
Well, yeah, I'll pass an order tomorrow. Let me give a thought over the night. What means what to be passed. Yes, there is a requirement of something to be done, but what is to be done is, say, the SIT has to be there. Then, if it is an SIT, then under the composition of the SIT, and then submit a report before this court by the SIT. And on the basis thereof, because the thing which we both of us are thinking about, yes, there as of now, unless conclusive evidence is there, because on one hand, the commission appointed by this court says that there is an overlapping. Then affidavit filed by them says that there is no overlapping. But we have also seen the bill of quantities, which is there to the work order, which only shows that a particular amount, does not say about 36.5, which he is saying. Now the question is whether these statements which are being made are on the absolutely false. Then on the next course of action is to take these people for task who has filed false affidavit and resort to proceedings under 340 of the CRPC against these people, and also contempt. It's another thing. We will take it up later on. But first, let me complete it with this.
For admission, item number 5.
Yes, madam. This is what scheme?
Lordship, this matter pertains to The right to education, Your Lordships. On the last occasion, the state was the recurrence of our direction, Lordship.
Yes. You have the rules? Get me the right to information, right to education. And consolidation. In these schools which you are referring, madam,
Lordships.
these are town A, these schools, there are 3 schools, no?
2 schools, Your Lordship.
We are concerned with 2 schools.
Yes, both are government middle schools, till class 8, Lordships.
Huh?
Till class 8.
Plus,
Class 8, government middle schools.
okay, so they will come under the schedule B, the schedule to the Right to Education Act 2009.
Um,
If you have that act, do you have the act?
I have the act, Lordships. Yes.
Yes, kindly see.
Lordship, yes.
If you see the schedule out there, if a school has for class 6 to 8, there's a requirement of having at least 1 teacher each for science and maths, social studies and language.
Yes, Your Lordship. And then if you see the schedule, Lordship, above 200 children, the teacher and student ratio should be 1:40
Where?
in the schedule, Lordship. Towards the end, point 1A.
At least 1 teacher for every 35 children.
uh,
No, we are not concerned. You are saying it is still class 8, no?
Class 1 to 8,
Eight.
Lordships.
So
Yes.
B,
So it-
1B, kindly see 1B.
Yes, Your Lordship. So both the points A and 1 should is relevant to this cases, Lordship.
So
So-
above 150 children,
Yes,
1A, if it is a school up till class 5, then it has to be a 5 plus 1 headmaster, 150 children.
yes, Lordship.
Above 200, then the people ratio says be 1:40.
Yes, above 200 enrollment,
Above
Lordship.
200.
So both these
And-
schools have more than 200 enrollments, Lordship.
Now, in both the schools here, there's a page note, relief support. Hindi and qualified maths teacher. Has affidavits been filed by the state education department?
Yes, yes, Your Lordship.
Now, do they comply with the RTE Act?
Yes, Your Lordship, I have stated everything in my affidavit, Your Lordship.
Let's see.
Sure.
Affidavit filed by the respondent number 226.
Yes.
Let us see in this school,
Para Street.
Mon Sector A. Annexure A, following are the
Yes,
teaching
yes,
and
yes.
non-teaching staff.
Yes.
You have a
We
untrained
have,
teacher.
12 teachers,
huh?
12 teachers in one town A, and in one town B, we have 14 right now. Your Lordship.
No, Mon A, you are having 12 teachers.
12, yes.
Oh, no,
That is-
he's a
that is-
carpentry instructor. He's a
Because, Your Lordship,
matriculate.
This has been filed in the year 2022,
Hmm.
on February 2022.
Hmm.
But today, the latest instruction I got is that there are 12 teachers in one town A.
A.
And.
And
14 teachers in
so,
one
so,
town
so,
B.
so Mountain A,
Yes.
do they have a Hindi and maths teacher?
They have all except Hindi, they do not have.
Huh?
But the Lord- in one town A, there is no Hindi teacher,
Okay.
but the Lordship say,
You can have a language, it may have a, you have any other, like in Assam, we have an Assamese,
We have this alternative English. Alternative English. Yes.
alternative English,
Yes, yes.
okay. So that is there, and maths also.
Yes, we have.
But,
maths.
but annexure A
Yes.
are the teachers.
Mm.
Now, if these teachers shows that the educational qualification happens to be matriculate for 2, 3, 4, and 5 under metric. Now, can these people teach in view of the NCT regulation, which stipulates a particular, there is a requirement of having a particular qualification?
Exactly, Lordship.
Then, can you say that these to come within the NCT regulation? More particularly, if you
So
see
in
that
the
judge,
program, they have been mentioned as untrained teachers.
understood, but how can you then say these people to be, have any teachers? Who is a maths teacher? Show me. MA Education, one teacher is there, number 7. MSc, he's a maths teacher?
Lordship say, in the village, there is a practical difficulty also. Because mostly the students are from that locality. So the teacher has to be from that locality in order to teach the students in their own dialect, Your Lordship. So a person from different district is facing difficult to teach the students of that area. And we have a very less number of students enrollment also, Your Lordship.
Madam, this act has come in 2009.
Yes.
We are 16 years.
So the Lordship, whatever project schemes we got, we implemented that, Your Lordship. And all these things, it has to be approved by the PAB. Unless it has been approved, Your Lordship, we don't have the fund to carry out the developmental work. So this morning I've been
No,
told.
you are saying that you don't have funds. Are those central government schemes nothing to do with them? The Sarva Shiksha, RMSA.
Yes, they have, but
Why you are not bringing them out here?
no,
Because that is
they
one
have
of
to
the,
put up the proposal, the project report, proposal, and only after they put the proposal, if the project approval board approves only, money will be sanctioned.
you knew about this
So,
long time
Your
back.
Lordship, regarding with the my learned friend who has filed her additional affidavit regarding about the status of the school, it's a very way back photos. That photo was taken in the month of June 2023. But last year, in the month of December 2023, work order has been allotted to a particular firm for development of the renovation and the construction of the.
That is
additional
also a
classroom.
fund which the central government
Yes,
gives.
so in respect of Motown D, so PAB, it sits only once in a year. Sits only once in a year, and right now it is sitting. So we do not know whether regarding.
Have you made the request for
Yes,
these
so-
teachers?
Yes.
Have you made the request for these teachers to be given? Because in that earlier case, I could see that you have appointed a lot of people out there. In 2010 and 2013, you have appointed 2,209. And thereafter, in 2015, you have appointed a whole lot of people. So under such circumstances, where are those teachers? I think Mon is the capital of what? The
It's a
district.
district of Mon
Mon
district.
districts,
Lordship. District
Mon.
headquarters.
A district headquarters school does not have those teachers, availability of those teachers, whom the state government has brought it within their fold. And as per the NCTE regulations, these people cannot be considered as teachers at all. They don't have have they qualified for the TET? Without a TET, how can they do so?
Lordship, in my affidavit, I have mentioned that paragraph 4, page 6, page 4, paragraph 6. It is stated the government middle school, Motown B, was upgraded from primary section in the year 2016 during the process of rationalization. Since its inception, the department has undertaken civil works in relation to the said school base construction of the school building in the year 2012 to 13, provided one additional classroom ACR in the year 2000.
Which affidavit 2, 3, 4, 5, and 6? Affidavit of the respondent number 2,
Yes, yes.
per page?
Page 4, paragraph 6.
Paragraph 6, huh?
Then construction of boys toilet and 2 girls toilet in the year 2014 to 2015. And construction of 2 additional girls toilet in the year 2016 to 17. The school has 8 classrooms and a teacher's common room cum office. The school is also electrified with solar power and has 1 computer and a TV set provided under computer aided learning. Although a separate library is yet to be increased, the school has been provided with multiple library books. Unfortunately, the school is located in a landslide prone area, and as such, the school building is adversely affected. Then the other one is regard to Motown A. The school was upgraded in the year 2010 to 2011. After its upgradation, the department has been relentlessly working to provide the basic amenities required for the school. In the process, the department has undertaken the construction of the school building in the year 2010 to 11. In the year 2012 to 13, 1 ACR was provided to the school, a common toilet and a girls' toilet were constructed in the year 2012 to 2013. The school was provided with drinking water facilities in the same year, and another ACR was provided to the school in the year 2016. The school has been electrified with solar power and connected to PhD for drinking water. Presently, the school has 9 classrooms and 8 store-cum kitchen. The school is fenced and gated, and the department continues its effort to provide the basic needs of the school. Both schools are sufficiently staffed with teachers for all subjects. It is also stated that the appointment of the chokidar and sweeper does not come within the purview of the program. Despite this effort of the department, much needs to be desired for the upkeep and maintenance of the school, as the same is largely dependent on community participation. The Supplementary states that the implementation of residential.
Who is appearing for the Nagaland Education Mission Society?
Your Lordship, I'm also appearing for the Nagaland Mission Society.
Then what are you doing? What are you doing? Understood.
Yes.
Here the problem with the state of Nagaland doesn't have the money. But what are the Nagaland Mission Society doing? Because they get the funds from the center.
Yes, yes.
Then, and it is 90-10.
Yes,
The
it's
center is
like-
paying you the money and why you are not doing it?
So, Your Lordship, I have.
See the plight of the school. See the photographs of the which you have enclosed. See the plight of these schools. GMC Town, GMS Mon Town D, page 19. It's all broken.
Well, Lordship,
How the government of India is funding, and in spite of that,
It says that it is on the,
GMS, the Mon Town A. See the plight of these schools.
it's in the landslide prone area. It's in the landslide prone area. This is what we have stated in our.
Doesn't show anywhere the landslide areas and all. It is properly there. It is on front of it is it is clear.
So Lordship, now in the year December 2023.
From your own document, kindly see page 14.
1-4.
See the plight of this school. Yes, Mr. Yangamati, you are appealing for the central? Yes, now tell me one thing. Here is the government. The government is funding so much. The central government is funding so much to the state. And the Samagra Shiksha Abhigyan or RMSK, whatever, Ramsar, both of them, and now you have the Sarvajina Shiksha.
Samagra Shiksha.
Samagra Shiksha. Now, this Samagra Shiksha not only deals on the question of payment towards the teachers, also deals with civil infrastructure. Then you are paying them. Why they have not done anything? On the face of it, it seems nothing is being done. Secondly, the central government categorically direct that all these schools should follow the NCTE regulations, which have been amended time to time. It is the requirement that these teachers should, more particularly the primary teachers, should have the TET qualifications. Nothing. How can this happen? Huh? No. If the education, then ask them, let the state not take a single penny from you. They're taking all the money from you. You have been sponsoring all along. And now they are saying that they have not done anything. What infrastructure they have done on receipt of the funds? They must have received funds in respect to these schools. Or have these schools out here have been identified by identified schools out here for the purpose of these SSA or RMSA schemes?
Yes, yes.
Then if that be so, is the central government not providing you the funds? Has the central government filed an affidavit? What do they say? Let's see. Tejpal Singh, yes. Samagra Shiksha, yes. And 90-10, yes. Page 9. Play materials, all these things are being provided. There shall be a library in each school, building, all weather building consisting of at least one classroom for every teacher and an office room, barrier-free access, separate toilets for building. These are all these which are there as per the RTE Act. And see the funds which have been given. Secondary education, elementary education. Yes. Hmm? Yes. Everything, even for strengthening of the school buildings, existing buildings also, funds are being released. What are they doing with the funds? Now, Madam Additional Advocate General, what do you say about the affidavit which have been filed by the central government? What steps have you taken pursuant thereto?
No, Your Lordship,
It doesn't show that you have done anything. The photographs are completely,
I stated that those toilets, those classrooms.
everything is being funded, 90-10 it has been funded.
And for that reason, like, we have placed our affidavit showing all the documents. So the petitioner, so I'm saying that they will.
Are you saying that the strengthening of the existing building and the photograph at paragraph page 14 shows anywhere that you are strengthening these buildings in this manner?
So you know,
These are all temporary structures. We call in Assamese Torzabera. Yes. See, everything is broken. These are all done under the Nagaland. It is Samagra Shiksha. Nothing is being done. It seems that the state government has, the state mission society has been doing it at its own will without caring what funds the central government have allocated. And therefore the petition is before this court. Madam, in this case, we are concerned with how many schools?
2 schools, lordships.
Mon Town A and Mon Town D.
D, lordships.
And both come under the Samagra Shiksha.
Yes, yes.
And the central government has categorically stated in their affidavit as to how much funding they have given.
Yes, lordships.
And then also the state have not shown the utilization
Lordships.
in the affidavit. File your affidavit on that. What utilization you have taken from after all the fundings which have been given by the central, as to why you don't have, if those are having the, as per the schedule out there, categorically, if it is up till class 8, you are required to have these the number of teachers. So, what is being done? And all these things are being funded. And Mon being the capital of, district capital of
District headquarters, lordship.
Mon.
Yes.
You don't have. I would have understood if it is in the outskirts of there in Kifri and all, you may think so.
No, but
But here is a town in Mon. Page 10. Yes, yeah. Yes, see how much amount it has been given. Secondary education, it has been given, elementary education, and Mon has only 2 schools, madam.
There are more, lordship. But in the this case is
No,
covering
no, no,
only 2.
Mon,
There should be more, your lordships.
more in Mon.
Yes.
Okay. Non-recurring, recurring. And this is up till 2021. And I think thereafter you must have paid for furthermore. Mr. Yangavati, you do one thing. Can you please, by way of a short affidavit, as to what is the amount you have paid for Mon district as of now? Because this is an affidavit file stating up till 2020-21. We want it till 2023. Because 23 is over now.
Because the petition was started in 2021.
Yes, yes. So therefore you file it as to what it is being done. And we ask them to file an affidavit, how they have utilized, taking into account as to whether they have done it in terms of the RTE Act. Because the affidavit which have been filed does not show that there has been an application area or the funds have been utilized in the manner in which it has been given. The instant PIL has been filed, bringing to the attention of this court the non-implementation of the provisions of the right of children to free and compulsory education Act 2009, for short the Act of 2009, insofar as the two schools in the town of Mon, being GMS Mon Town A and GMS Mon Town D. This court have also taken note of the affidavit in opposition filed by the respondent number 1, wherein it has been mentioned that the central government have been providing various funds from time to time under various schemes to the Mon district. The funds which have been issued are in respect to salary support for teachers, comma, semicolon, for repairs and maintenance, additional classrooms, and for recreating dilapidated buildings as per the state's proposal. Further, the funds have been issued for purchase of desks and benches, comma, semicolon, library, ICT/smart classrooms, etc. It is also seen that from the said affidavit that for the Mon Town School, the Government of India under its ALT bracket appointment of language teacher bracket close scheme had given funds for salary of Hindi teachers. This court have also perused the affidavit filed by the respondent numbers 2 to 5, 2 to 6, along with the enclosures to the said affidavit. The said affidavit is completely silent as to how the funds which have been received, as stated in the affidavit filed by the respondent number 1, have been utilized. In the said affidavit, various enclosures have been made as regards the teaching staff of the two schools in question. As regards the GMS Montown A school, the question arises as to whether the teaching staff has the requisite qualifications as is required under the NCTE regulations. It is also seen from the affidavit filed by the respondent number 1 that the funds which have been issued, the details of the funds issued up till 2020-21 have been given. Under such circumstances, this court fixes the matter again on 27 or 20. When can you file that short affidavit?
Will that be possible? Within that short time, may not be possible.
Only bring that detail, nothing more. Only one page. We don't require anything else. Only that affidavit as to how much funds you have released after 2020-21.
After 3 weeks or 4
List this matter again on 3rd of April 2024. On or before the date, the central government, the respondent number 1 shall file an affidavit only to the effect as to how much additional funds have been released to the Mon district after 2020-21. The state shall also file an affidavit. The respondent numbers 2 to 6 shall also file an affidavit as to whether, clarifying as to how the amount which have been received from the central government in terms with the Samagra Shikshas Abhijjan have been utilized insofar as the 2 schools in question. Further to that, the respondent state government shall also file an affidavit as to whether the appointments of the teaching staff which have been done is in terms with the schedule to the Act of 2009, in as much as the state is obligated under the provisions of the said Act to provide in terms with the Act of 2009. List accordingly.
For admission, item number 6.
Yes, state healthcare, what has happened? Now, what are you doing? You have the draft ready.
Yes.
Now you are going to make the rules.
No, rules. Approved by the ministry, government, yeah. Now we are.
When are you appointing the state mental health authority?
Lordship, there's only one existing of the lordship, but they have to be back to lordship.
Huh?
Because they have to appoint new members. Because as an interim measure.
You take that mic, mic. Yeah, we still have a COVID precautionary glass in us between.
As an interim measure, authority was constituted to look into the Act lordship. Now the rules have been framed as per the direction of the government of India. We have sent a draft rule for its assent lordship. They have sent the back to us with certain correction to be made. After the correction was made, lordship, the matter was placed before the cabinet. Cabinet approved it, and the matter was sent to the government ministry of health. They have approved it.
So this is being approved.
Yes.
Now the next step is for appointment of the mental health authority.
Yes, and to notify it, lordship.
How, where, how long?
Lordship, since we have received only today, I just got.
We got it there before on 21st only.
Lordships, we got the news.
We received from the ministry officially. So it was, I've received from the WhatsApp lordship.
Because the council, Mr. Muaim Chin had there, he only said last time that already it has been approved by the central government. So when are you appointing? That's the only case out here.
So logically, the time frame will be given, Lordship.
We fix it on 27th of March. I think by then you can do it.
Lordship will do that.
Yes, Lordship, for publication of the rules in the Gazette, Lordship.
The rules in the Gazette will be published.
Yes,
They
it
have
has
no
to be notified,
problem.
yes.
When are you publishing it?
So Lordship, within the time frame, Lordship, for publication of the rules in the Gazette, as well as appointment of the members of the office.
We are concerned with the appointment of the year, no? Nagaland healthcare rules, what have we asked for here?
Because there was a delay from the part of the ministry, Lordship, in approving it.
So to constitute the state mental health authority here, constitute the medical boards as mandated under here. So we are having these two prayers here, no?
Lordship,
Lordships.
So now the rules having been now done,
approved.
you will be notifying it
Yes, will be notified.
in the Gazette.
Yes,
And thereupon appoint
appoint the members of the board as well as.
member and yeah. So as well as to constitute the mental health review
Yes,
board.
yes.
So these things will be done. We have it on 3rd of April. In the meantime, you do the
Lordship.
Obliged.
the instant PI has been filed seeking drawing the attention of the to draw the attention of this court that the Mental Health Authority, as mandated under the Mental Health Care Act 2017, have not been constituted in the state of Nagaland, and further seeking a direction that the mental health review boards be constituted. This court have seen the reports, have seen the various orders being passed, wherein on account of the central government not approving the rules, the draft rules, the state was not in a position to publish the rules which have been framed, and thereupon, and it was only on account of that impediment, the state mental health care state mental health authority could not be constituted or established, as well as the mental health review board could not be constituted. Full stop. On 21/2/2024, when the matter was listed, the Mr. Mua Imchen, the learned senior government advocate, had submitted that the central government had accorded approval to the draft rules so proposed by the state government. Today, Mr. Mujoy, appearing on behalf of the health department of the government of Nagaland, had submitted that by the communication dated 20/2/2024, the state mental health care rules framed by the state government of Nagaland have been approved by the central government. Full stop. A copy of the said communication issued by the Undersecretary to the Government of India, Ministry of Health and Family Welfare, have been placed before this court during the course of hearing. The same is kept on record and marked with the letter X. Mr. Mujoy, the learned counsel, appearing on behalf of the Health and Family Welfare Department of the Government of Assam, of the Government Health Department of the Government of Nagaland, submits that in pursuance to the said approval, necessary needful actions would be taken for publishing the Nagaland state healthcare rules in the official gazette, and thereupon appointment or establishment of the state healthcare authority, mental healthcare authority, and the constitution of the mental healthcare review board would be done. He submits that the same would require some time. Accordingly, this court fixes the matter on 3rd of April 2024, on which date the learned counsel appearing on behalf of the state government shall ensure that in the meantime, the state mental health care list the matter again on 3rd of April 2024. In the meantime, the state authorities shall take appropriate steps for publishing the state mental health care rules in the official gazette, and also establishment and also take appropriate steps for appointment and establishment of the appointment and
Constitution of
establishment
State
the
Mental Health Authority.
Take appropriate steps, effective steps for constitution / establishment of the state mental health care authority, as well as to constitute the mental health care review boards. List accordingly.
For admission, item number 7.
Please, Your Lordship. May be granted 3 weeks time, Your Lordship, on account of the Nagaland Legislative Assembly session. The respondent number 3, 4, and 5 are engaged in assembly.
You say that you have already established the Nagaland State Food Commission,
Yes, Your Lord.
on the basis of which you have given a document on the last occasion. This was done in the month of March 2021.
Yes, Your Lord.
You have granted appointment to the chairman. You have granted appointment to the LD staff. You have given appointment to 2 members. You are paying them the remuneration.
Yes, Your Lord.
This court only asked you only one thing: where is the office?
Yes, Your Lord.
Yes.
Nothing more than that.
I may be granted some more time.
Why? Who only asked you where the office, where she can go?
Yes, Lordship.
We don't want anything more.
And if the office is actually functioning, he can answer now also.
So that is the only
That's
thing.
it. just
I have
need a location,
instruction to pray for some more time.
Huh?
To come with the proper affidavit.
Wouldn't that amount to misappropriation by the IS officer who was appointed? He has been paying 50,000 without an establishment of the office?
No.
That's a very serious infraction.
Not the IS.
You have appointed a chairman. You have appointed a secretary. You have appointed a member. You are giving them the salary of 50,000 or whatever may be. The people who are the LD assistant, as the LD and computer assistant, you are paying them a salary of 22,000 or something, and they don't have an office to go.
Your Lordship, not the IS officer, public social worker.
Who?
The chairman who was appointed was a social worker. Not
He's a
the
social
IS.
worker.
Yes, Your Lordship, not the IS officer.
Social worker also. Isn't that the requirement of the rules to have an IS officer? See the qualification. Isn't that, madam?
Lordship, yes.
Yeah, then you don't have an office. I didn't ask some more than something. I only asked you where's the office. You don't know.
I may be granted some more time.
To know where the office is in Kohima.
Yes, my lord. My lord, can want some more time.
Mr. AG, it shows very poorly on the state of Nagaland. You have established an institution and there is no office. and it takes 7 days to know the location of the office. What did I ask? Whether the state Nagaland State Food Commission is presently functioning, and further as to from where the State Food Commission is functioning from. And you require 3 weeks for that, to get that information. The learned AAG have been endorsed with cases which obviously does not inspire the confidence. Where is it? Office?
Seeking time for filing petition and everything from the department.
Understood, but do you know where the office is? We have instructions, but where is the office? Lekhok. This court, by an order dated 21/2/2024, upon taking into account the constitution of the Nagaland State Food Commission for the state of Nagaland, by the notification dated 15/3/2021, and the various appointments made to the office staff, to the members, and various appointments made in pursuance thereto, on 22/7/2021, 23/3/2021, and 4/4/2022, had asked the state of Nagaland to apprise this court as to whether the Nagaland State Food Commission is presently functioning and from where the State Food Commission is functioning from. Full stop. Mr. So-and-so, the learned counsel, additionally, he submits that to provide this instruction, which in the opinion of this court is a simple instruction sought for, he requires 3 weeks' time. Full stop. The said aspect does not inspire the confidence of the court. Be that as it may, this court fixes the matter again on 6th of March 2024, on which date the state hopefully can apprise this court as to whether the Nagaland State Food Commission is presently functioning and from where the Food Commission is functioning from.
Right.
For admission, item number 8.
Yes. What is the order passed?
That is which order is at page 193.
Yes, why are you challenging it?
Lordship, we hear operative part is at page 197, Your Lordship, I mean, the Lordship, 197, para A. The case of the state respondent is that although the name of the petitioner was included in the list published, but there is no record available to show that she had appeared for the test in the given date. What is important to notice here is that the state respondent has not totally denied that the petitioner did not appear for the test on 15/7/2005. But what they mean is that the report showing her appearance for the test is not available with them. The other contention of the state respondent is that in view of the circular dated 6/4/2018, which was issued pursuant to the decision rendered by this court in WPC 145 of 2017, the regularization of the services of the petitioner cannot be taken up. A revision of the judgment of order dated 3/18 goes to show that this court had directed the state respondents not to regularize the service of any person in terms of the order dated 11/8/16 and the order dated 4/8/2008. It may be seen that the memorandum dated 18/2/2004, which is irrelevant to the present case, has not been referred to in the said judgment and order. Upon completion of 5 years of service after her initial appointment on 29/4/1992, the petitioner become entitled to be considered for regularization in terms of the office memorandum 18/2/2004, and her name was also included in the list of eligible teachers published in the local newspaper dated 29/6/2005. Therefore, it might consider the absence of specific denial by the state correspondent that the petitioner failed to appear for the test on the list specified, she will be entitled to be considered in terms of the office memorandum dated 18/2/2004. Lordship, this is no more in existence, Lordship. Admittedly, all the teachers who were similarly placed have all been considered and regularized in terms of the office memorandum dated 18/2/2004. As such, I find the grievances expressed by the petitioner being legitimate. Accordingly, the writ petition is disposed of with a direction to the respondent to consider the case of the petitioner for regularization in terms of the office memorandum dated 18/2/2004 within a period of 3 months from the date of receipt of a certified copy of this order. It is also made clear that this order should not be treated as a precedent in view of the fact that the case of the petitioner has been found to be left out at the relevant time, while all other similarly situated teachers have been given the benefit of the regularization. So, Lordship, accordingly, we have communicated.
No, tell me one thing.
Yes,
Whether the petitioner herein was appointed,
yes. On ad hoc basis.
was initially appointed to a sanction post.
Yes, appointed on a sanction post.
No,
Yes.
was appointed on ad hoc or contract
On
basis
ad
on
hoc.
to the sanction post?
Yes, there is a.
Let's see
sanction
her appointment
post.
order.
Yes. Appointment order is at page 72.
Page
72.
72.
Lordship, 71 is the appointment order, 72 is a type copy. Srimati Caroline B. Kitchen, BA, is hereby appointed as ad hoc as graduate teacher at GMS Teacher Colony under the establishment of the Deputy Inspector of School under.
Against her ad hoc. Okay.
Yes,
So this was done under there. Now, as per the scheme of 18, the office memorandum of 18/2/2004,
yes,
there are majorly two categories. One is category number 1, wherein there are 3 subcategories,
yes.
and category number 2 is who are on fixed pay
No, no.
without sanction post. Yes, kindly come to page 73. Sitting out here for 2 weeks, I have. On the page 73. Isn't it?
Yes.
Category 1 are ad hoc contract appointments
Yes.
made against sanction post. It has 3 categories.
Yes.
The first category are those persons who are having 10 years of service
Yes.
to a sanction post. The second is having 5 to 10 years of service.
Yes.
The first category does not require an examination. The second category requires both a written and viva voce.
Yes.
And the third category, which is below 5 years, they would be only given what you call the age relaxation, nothing more than that. These are the 3 categories. So subcategories. Now the petitioner claims that he or she falls within the second category.
Yes, second category.
And the question out here is, as on that date,
Yes.
the petitioner's advertisement was made. There was an advertisement made wherein the various names of 260
Yes.
teachers were there,
Yes.
wherein the petitioner's name was also
Also
there.
there, yes.
And the petitioner said that he has appeared, whereas you don't deny.
No, we see that she has not appeared for the examination, for the suitability test. Even in her affidavit in reply, Your Lordship, she stated that on the date of the suitability test, she was late.
She was late.
Yes. So when she reached the Administrative Training Institute, her name was called out, Your Lordship. That's what she has stated. So we do not have the report, Lordship. The fact that she did not appear, that's why.
So the
her report
question
was
of
not there.
granting an opportunity
Yes.
or regularizing her
Yes.
without the recommendation being made, because that
Yes.
after she
That's-
passes out in the written and viva voce,
Yes.
then only the recommendation can be made.
Exactly. And Your Lordship, we have made it very clear that on the day of the interview, they are supposed to bring all the original documents. So petitioner also admitted that on the date of that interview, she does not have all the original documents. So we are saying that she did not appear for the interview. And the Lordship, after a lapse of 15 years, she filed the present petition, Lordship.
Delay in latches.
Yes, seeking for regularization of case under the OM dated 18/2/2004, which is no more in existence, because 18/2/2004 was already superseded by the OM 2007, which was subsequently superseded by 2008, and that 2008 OM was declared to be unconstitutional by this honorable court, division bench of this honorable court, whereas the single bench, single judge says that in that order, the OM dated 2004 was not mentioned in the judgment and order. That's why as a one-time measurement, petitioner should be regularized against that OM. So you know, when the OM is no more in existing, from where we will get the source to regularize the petitioner. So in the meantime, we have accordingly communicated to the petitioner that we could not consider her case. Then in the meantime, the petitioner filed the contempt.
Where did you communicate to the petitioner
Yes,
earlier?
Your Lordship.
When?
At page 203, Your Lordship, to her counsel. Page 203, 9th November 2022.
No, this was only there in 2022.
Yes.
No, this is only in pursuance to the order passed by the learned single judge.
Yes.
Not earlier.
Not earlier, yes.
Earlier you did not.
After the passing of the single judge.
When was that particular list published? Those who were regularized at that point of time? Must have been in sometime in 2006.
2007.
It was not published, Your Lord.
Huh?
It was not published.
No, it was published. 2006-07. And these people were given 2006. It was published.
Only after the petitioner filed the writ petition, these came together with the record, Your Lord. Otherwise, it was never published, Your Lord.
No. Then how did those people get regularized? Those people have got regularized.
Yes, then in 2000,
I've seen.
yes,
No,
2000,
Mr. I've seen, because there was another case I'm dealing with in respect to the same office memorandum.
page 121, Your Lordship. Lordship, page 121.
Yes.
Yes, that is what I've seen.
Yes.
Minutes of the meeting.
Yes.
So these are the persons who were regularized in terms of the suitability
But
test
this was not
conducted on
published.
13/7/2005.
So that is what they were regularized.
Yes.
So-
But petitioner did not appear for the test.
No, Your Lordship.
So Your Lordship, for that matter, her admission in her affidavit in reply, let me take you to her admission. Your Lordship, page 178.
Now, what is the name of the petitioner?
Okay,
P. Caroline.
Caroline Im Singh.
Yes.
Her name is here at page 133.
In the not for appearing before the, yes, it is page 77.
No, page 133. The following candidates were informed during the course of the interview about the need of submission of the complete documents in original and also. So here it is not there. While continuing, it is detected that there were no signature for unauthorized friends. So necessary HSLC certificate. The following candidate cases were initially found to be appointed as substitute teachers who were on deputation after absorption and
Her name is not here, Your Lordship.
HSLC said the following is either did not taken up or rejected for reasons. Here the names are not there.
Yes. Because she did not appear, because of which.
So it was not taken into consideration at
Yes,
all.
nothing. So Your Lordship, her admission. in
Okay,
her-
we admit this.
Yes.
Your Lordship, her statement that I did not appear is not so, Your Lordship. Your Lordship
It's
may-
okay.
Your Lordship may go to
Let
the-
let the wisdom of another division bench decide. And we are only admitting it.
just to make it clear, Your Lordship, the petitioner's statement
has been misstated by the state respondent. So your lordship
But-
may kindly
but-
allow me to take
But
the.
the only worry out here,
Yes.
about other things I'm not. You see, the regularization, this court can't direct.
Your lordship,
It is a scheme to be done by the state.
yes,
The state had a scheme in the year 2000 and gave it on 18 to 2004.
yes,
If it is a case where a person concerned was rejected in terms with that scheme, and when the state categorically says one thing, that she did not participate, whereas you say that you have participated.
yes, your lordship, yes.
So the question arises that there was a legality or illegality in depriving you. But the fact that at that point of time in 2006, these people were very much appointed, or 2005, 2006, these people were very much appointed. What were you doing?
No, in 2010 and 9 and 11 only the orders were issued. Your
No,
lordship.
2005, 6 only these people
No,
were
no, no,
appointed.
your lordship, in 2006, 2007, your lordship, if your lordship may go through the letter, it is in 2007 that this committee said again, in 2007. And in that sitting, they submitted a recommendation, but it was never published.
No,
Then
no.
later on.
No, I know it for a fact because there is another matter I have taken up of Mr. Takamasa, which I'm going to deliver the judgment tomorrow. There I've seen it. There are those people initially, what has happened of these 10 years, category 1, there were 183 teachers who were appointed, regularized,
Yes.
first batch. And they were given the effect from 16/1/2004. Because 16/1/2004 is the date on which the cabinet had approved it.
Yes.
Although this is dated 18/2/2004. Now the second set of 40 teachers were appointed from this who had 5 to 10 years. First happened in 2006.
Your lordship, the orders were, if your lordship may allow me to take your lordship to the actual order that was passed, regularization order.
Anyways,
It was in
we-
2009.
Mr. Counsel, we will consider this some other time, but as of now, we need to admit this and state. Heard Mr. Ms. So-and-so, the Lalital additional AG, and Mr. So-and-so appearing on behalf of additional AG appearing on behalf of the state. Appearing on behalf of the appellants, and Mr. So-and-so appearing on behalf of the respondent. Taking into account so we have to duly peruse the grounds on which the instant appeal has been filed. And we are of the opinion that the appeal requires to be admitted. Accordingly, the appeal stands admitted. The respondent being duly admitted, being duly present, and have also been served with the copy. This court fixes the matter for hearing on, when do you want?
Next week, your lordship.
Lordship, next week, I want to hear after 3 weeks. Your lordship.
What? 2020, 23, 2024.
Your lordship.
First, that is done for the main appeal. This is an application filed by the appellants, applicants of the appellants, seeking stay of the judgment and order dated 28/6/2022, passed in WPC number 61/2020. This court, having taken into account the grounds and reasons, grounds on which the appeal has been filed, and having admitted the accompanying appeal, we are of the opinion that the said impugned judgment and order dated 28/6/2022, passed in WPC number 61/2020, requires to be stayed pending disposal of the appeal. Accordingly, the judgment and order dated 28/6/2022 passed in WPC number 61/2020 stands stayed till the disposal of the accompanying appeal. I stands disposed.
For admission, item number 8.
Yes. Oh, same matter. No, this is the same matter, no? I've done it now.
Item number 9.
Yes,
Lordships, in the last occasion, I was permitted to take justice service upon respondent number 6 and 7.
Ah,
So to that effect, I have filed my affidavit, Lordship, on 26/2/2024.
okay, then,
Yes, Lordship.
yes, service is complete
Yes,
upon
Lordship.
respondent number 6 and 7.
Yes, Lordship.
What do you want now?
Lordship, here I am aggrieved by the judgment and order.
What does it
Order
say?
dated 35/2023 passed in WPC 316 of 2017, Lordship. I'm not aggrieved by the whole judgment, Lordship, but I'm aggrieved by few of the paragraphs. 3 paragraphs of the order, Lordship. If I may take your Lordship to
I
the,
hope it is not in the last 3 paragraphs.
no, your Lordship. No, your Lordship. It's paragraph
Yeah,
12,
12, yes.
12, 20, and 21, your Lordship.
Why are you aggrieved?
Lordship, here, as per the finding of the single bench judge, Lordship, here it states that we have the Jaluki village has been compensated for the land we donated for the establishment of the administrative
Para
headquarters,
12.
Lordship. Yes, Lordship.
Para 12. On the other hand, so and so, while admitting the existence of the agreement executed between the landowners and the government has submitted that the land in question was compensated by the government by payment of money for 100 acres of land at Jaluki, which was received by so and so. Were you a party?
No, your Lordship. Lordship, for that, Lordship,
No, no, this is a
I have-
submission only, madam. This is only a submission.
Yes, Lordship.
Then-
That is why, Lordship, this order was passed in my absence. I was not made a party. So
Understood, but,
that is why, Lordship, I filed an IA
Ah,
under the provision of the High Court rules, Lordship, and praying for the leave of the court to allow me to file this writ appeal, and this IA was allowed, Lordship.
okay,
Yes,
understood. But why are you aggrieved with 12? It is only madam is saying.
Lordship, this states that
No,
we were
whatever
compensated.
madam says, does it, if it is
Yes, Lordship,
recorded,
it-
becomes the order of the court?
Lordship, it is adversely affecting us, Lordship, being a village, we were not compensated in any way, Lordship.
And which more paragraph? Paragraph 12 and?
20 and 21, your Lordship.
Wait. 20, it appears from the affidavit in opposition filed by so and so that it further appears that there is a policy of the government doing and 21.
Yes, Lordship, 21. And Lordship, this order was solely passed based on a document.
We can dispose it off, saying that these observations shall not affect the right of the village in respect of claiming any compensation. No, that is the subject. Shall not prejudice. These observations shall not prejudice the appellant if they claim a compensation which shall be decided on its own merits.
Lordship,
No, you see, as of now, have they made a claim?
They are claiming on the basis of land ownership.
Very well. Land, no, we are concerned with the village.
yes, Lordship.
The village have not claimed anything
No, your Lordship, we are not.
out here. Have the village asking for any compensation from you?
Right now, no.
Now the question arises as to whether, because they were not a party.
No, Lordship.
They were not a
The-
party
okay.
in that case.
Therefore, the question arises as to whether the observations made herein would affect the petitioner, the appellant's rights to claim compensation. We are of the opinion that the observations which have been made shall not affect the appellant to claim compensation if otherwise entitled under law.
Or if they're.
That is what I'm saying. I'm not unding it. If otherwise entitled to.
Lordship, if there is
But
a-
these observations shall not cause a prejudice to them as if it is otherwise entitled.
Okay, Lordship, if there is. Yes.
So nothing remains unnecessary keeping. You want the matter to be kept pending, you can. We have some lawyers in Gauhati who likes the matter to be kept pending for long, who are actually,
Lordship, we are also, actually, Lordship, the judgment passed in the single bench, Lordship.
why?
It was solely based on this document dated 13/3/1971, Lordship.
Now, how are you agreed?
So, no, so Lordship, here, that we are saying that this document is fabricated. It's a false document, Lordship,
So,
which was produced in the court and then.
the instant writ appeal have been filed by the appellant. Being aggrieved by certain observations made in the judgment and order dated 30/5/2023 in WPC number 316/2017. We have heard the learned counsels appearing on behalf of the appellant as well as the respondent in the state. Though the appellant is aggrieved by the observations made in paragraph number 12 and in by the observer is aggrieved by the contents of paragraph number 12, 20 and 21, wherein the learned single judge had made certain observations that the appellant village had received certain compensation for a particular plot of land.
Yes, Lordship.
It is the this we have duly taken note of that the appellant village was not a party to the said writ proceedings. The only grievance which we see is that the said observations, the only grievance which we could discern from the submissions made by the learned counsel for the appellant is that these observations would affect the right of the appellant to claim compensation if need be, inasmuch as these findings observed or these findings made therein, more particularly at paragraph number 20 and 21, may affect the appellant village if not put to challenge in future. Taking into account the above grievance and also for taking into account the above grievance And also the fact that the appellant was not a party to the proceedings. We observe that the observations made in paragraph number 12, 20, and 21 shall not act shall not prejudice the appellant if the appellant is otherwise entitled under law to any compensation. We, however, make it clear that this court is not interfering with the judgment and order dated 35/2023, passed the impugned judgment and order dated 35/2023, passed in WPC number 316/2017, insofar as the dispute between the petitioner therein vis-a-vis the respondents therein.
Lordship, the relief I'm seeking here in this appeal, Lordship, if your Lordship may come to my prayer, Lordship,
Yes.
page number 21.
Mm.
Lordship, here I'm praying for setting aside the conclusion of these paragraphs from the judgment, your Lordship.
No, your only thing is paragraph 12, 20, and 21 in the human holding that the land donated by AR for establishment has been
Lordship.
compensation.
And
This
Lordship,
I have the whole thing.
we have no intention to ask for compensation, Lordship. We have-
Understood.
yes, Lordship.
Then therefore you are asking that these paragraph 20 and 21 should not be. Why will you be otherwise aggrieved?
Lordship, it's the village name is at stake, Lordship. Here we were not compensated in any way. So, and as per this document, it states that we were paid an amount of 1 lakh, allotment of 50 acres of land, and also a plot of land at Dimapur. This document states that we were compensated with all these things, Lordship. However, till date, we have not been compensated with in any form, Lordship. That is what I'm trying to. And as per the agreement, Lordship.
One more line out there. The observation, this court, we further observe that the observations made in paragraph number 12, 20, and 21, that the appellant village have been compensated. Shall not apply insofar as the appellant village in question. So far shall not apply insofar as regards the appellant village in question. Inasmuch as the said observations were made in absence of the appellant.
No, Lordship, if that is the case, then I have objection to that, because say, your Lordship, I'll point to the agreements as well as the document.
Lordship, yes, Lordship.
That
If
last
your Lordship
paragraph
can
may be
see.
related, if that is the case. Otherwise, Lordship, they have been compensated, your Lordship, all the documents I have. So if at all they are aggrieved, they should file a civil suit. Because see, your Lordship, the village, they have given the whole for the establishment of parent to Zelian Kuki Tribal Council. And in the agreement also, they stated that the cease
The
to clean
Ziliang
the land.
Kuki, that they were not a part of the agreement, Lordship. If I may take your Lordship to the agreement, Lordship. Lordship, in the agreement,
No,
it clearly
Madam, then
states.
in that case, how can I act on your writ petition, on writ appeal?
No, Lordship.
How
Lordship,
can
if
I,
I may.
because, no, why I'm saying, you are making those statements on the basis of a certificate?
No, Your Lordship.
Where's the affidavit? This writ appeal is on a certificate.
Yes, Lordship.
Then?
But Lordship, what I'm trying to say is, Lordship, there was an agreement in the year 1966, Lordship, between the village and the state, Lordship. And here in this agreement, if I may take Your Lordship to the agreement, Lordship, it's at page 50, point number 4. Here it's clearly stated that it's written that we decline to take any compensation for the land in question, but request to the government that government should give every facility to our village in the town area, such as opening of our village block, allotting plot in the town, and preference for government service. That was the only
No, we have to read
thing,
the
Lordship.
whole
So
conditions of the agreement as a whole, not.
Yes,
But
Lordship,
how
if
is
Your
it
Lordship can-
relevant in a case pertaining to an appointment of, I think a sweeper was there, no?
Yes, Lordship.
Or a peon, whatever it may be, how did the learned single judge take into account those thing as regards that village has been given?
Yes, because lordship, it's like
That
this.
is the point.
The
Lordship.
village,
We-
they have given the land.
Upon, you see the land ownership scheme which you are having,
Yes, yes,
this will be done as per the 2018.
yes, yes,
Now the 2018 says about a land ownership by a person.
yes.
It may be given to under 3A, 3B and C, 3C. It has to be given first 3A, this will come on 3B.
But lordship provide, if there is no compensation, then appointment will be given to, preference will be given to the land.
Understood, but why did the learned single judge have to go into the question of the village?
Well, the question is that.
Because that notification of 17/5/2018
Yes,
is only in respect to a person donating.
Because both the petitioner as well as the respondent, they are claiming the post on the basis of the land ownership.
No, that has to be individual to them.
Yes, Lordship.
It could not have, the learned single judge could not have made these observations thereby as regards the petitioner.
Yes,
No,
Lordship,
for
exactly.
the state government, we have produced this document saying that the petitioner or the petitioner does not have the right to claim on the basis of land ownership because the village has already donated the land to the Zelian Kuki Tribal Council and the Tribal Council has given that land to the government. And accordingly, the government has paid the money to the Zelian Kuki Tribal Council.
So under such circumstance, why did the single judge or the make an observation as regards the learned what you call the village,
Yes.
without the village being a party?
Exactly, Lordship.
So what is wrong?
Obliged, Lordship.
For admission from the supplementary cost list, item number 32.
Yes, government, who is appearing? Anybody from the government? PP? No PP? Where is Mr. Jimomi? Yes, Mr. Khalid.
Yes, Lordship, recent criminal appeal against the judgment by the Special Court POSCO passed on 16 to 23, Lordship. After the partial of the judgment, there are many things that the FIR upon which this case is based upon is filed by PW1, and he has filed his FIR upon a statement by PW2 after a long gap of 15 days. And in the judgment, nothing has been detailed even about the condolence of the delay regarding the filing of the FIR. And there was a delay of 15 days, Your Lordship. And during this 15 days, there is no abnormal behavior on the part of the child girl. Another part is that PW2, who happens to see this offense by himself, he never goes to the police station, he never goes to the police stations, he never files an FIR, never tells anybody about this heinous offense, Your Lordship. Then on a fine day, he meets the the relative of the victim girl tell this, I have seen this. Then they went to the parents. Then they held a meeting. Then after that, they went to the village headman, and FIR was lost. And instantly, the appellant was arrested. And since then, he's behind the bar, Your Lordship. There is total contradiction in the statement, even on the date of occurrence. There is contradiction in the statement, Your Lordship.
New one, not the old one. This is say 8 years old. This is old. New one. 2019, there's a book. Amendment is this. Punishment 5 years. Less than 3 years. Then the court say 377. 354.
Yes, sir. Yes, sir. Punishment. Notice to be given. Notice to be
IPC.
Bakti bukan notice issue. So bukan notice issue. Bukan notice issue.
Officer in charge of treaty deal.
Oh, delay pada. Procedural
Officers in charge. Yes, madam, you are there. We admit the appeal and issue notice to the respondent number 2, you accept, and as regards the bail, we issue notice. That will be subject to after notice. Appeal heard Mr. So-and-so, the learned J. Khalid, the learned counsel, appearing on behalf of the appellant. Ms. Esme, appearing on behalf of the learned PP, appearing on behalf of the respondent number 1. The appeal is admitted. Call for the reports. Issue notice to the respondent number 2. First, the petitioner would take steps by way of registered as well as usual, but within 3 days. First, victim should notice making it returnable on, we have it on how much, 18th, 2024. Steps upon the respondent number 2 by way of registered as well as usual by 1st of March 2024. First. It will call for the records to issue notice, making it returnable by someone who accepts notice on behalf of the respondent number 1. As regards the respondent number 2, the petitioner is directed to take steps by way of registered as usual. Returnable same date, 23/2024.
For orders, item number 10.
Yes.
Your Lordship,
What is
the
this?
service is complete.
Service is complete. Still awaited. Why do you say it to be complete? It says that the service report upon respondent number 2 is still awaited. Who is respondent number 2? Regional Manager, State Bank of India, Dimapur. Why didn't you? Respondent number 2 is Accountant General. Accountant General.
Your respondent number 2, the Accountant General.
So we have the Accountant General, Mr. Moju appears, and yes, he is there. The service is complete.
The instruction by the registry, no notice was served to us.
Okay. You appear, you'll take steps. Okay, he appears. So now the service is complete. Okay. Yes, heard Mr. So-and-so, the learned counsel appearing on behalf of the appellants. And Mr. So-and-so appears on behalf of the respondent number 1. And Mr. Nmujoy appears standing, you are a standing counsel?
Yes, sir.
Standing counsel of the Accountant General, Office of the Principal Accountant General, A&E, Nagaland, accepts notice on behalf of the respondent number 2. The petitioner, the appellant is directed to serve an extra copy of the memo of appeal during the course of the day. List the matter for admission on when? 21.
20 March.
Admission.
Your Lordship, the appeal is already admitted, Your Lordship.
Oh, appeal is admitted?
Yes, yes, Your Lordship.
Actually, the AG, I already struck out.
Appeal is admitted. List the matter. You want a hearing?
Yes.
List the matter for hearing?
Yeah, list the matter for hearing, Your Lordship.
We'll have it for hearing because the thing is there is a stay operating against you.
Yeah, Rohit, I would like to file the adjustment document.
Okay, you file. So list the matter for hearing on 3rd of April 2024. In the meantime, the respondent is given the liberty to file additional pleadings, bringing on record the documents as it deems fit.
Obliged, Lordship.
I won't sit in the single bench. We won't sit any further. In the division bench, I'll only sit in the single bench.
I already struck out the AG.
This is purely spirit and the petition in the petition. We have no role.
Unless you may say that only. And the registry shall also show the name of Mr. N. Mujoy. The registry shall also show in the cause list the name of Mr. N. Mujoy appearing for the respondent number 2.
Based on the
For admission, item numbers 1 and 2.
14 minutes, 11 and 14 minutes.
Yes, government, who is appearing? Who is appearing for the government?
Miss Lily.
Who?
Miss.
This land was acquired under the 1894 Act. Or the Nagaland Acquisition and Requisition Act. The Nagaland Acquisition and Requisition.
Lordship is there in the volume 2, Nagaland Court volume 2.
Now, kindly come to annexure 23 of your writ petition.
Annexure 23,
3 of your writ petition, page 68.
page 60,
68.
68. Annexure G.
Annexure 23
23. Dear
of the writ petition or affidavit in
dear
opposition.
affidavit, madam.
These were the proposals going on in the year 2012. Did you say at any point of time, we don't want to acquire?
Madam, this, our in this farm initial intention and the from this.
No. Did you say at any point of time, at that point of time, in 2012, prior to the acquisition, that you did not want the land to be acquired?
Madam, I have one additional affidavit I filed. Additional affidavit filed, my lord, by, my lord, it is annexure L, my lord.
Annexure?
Annexure L, additional affidavit, one additional affidavit filed by me, additional.
Yes, annexure L.
L, my lord.
Yes.
This page 10.
Yes.
Paragraph 3, man.
Hmm.
In view of your request to convene a meeting between the owner and the representative PC and representative headquarters for finalization of process of acquisition of the land of government of Nagaland for further handing over to BRO on lease. The representative of headquarters will report it.
No, understood. This is in 2011.
Yes, ma'am.
When the question of acquisition is going on, all these things were being pointed out to you. Did you at any point of time thereafter say that we don't want this land on lease? Acquired, this land should not be acquired.
In every occasion, our this now in Nagaland, this government will acquire the land and this thereafter at 2005 onward, and these any organizations and government they will on lease.
Where is it? Where is the policy for that? That only they will lease, they would not give it to the requiring authority.
There, if in operation page 106,
106.
106.
Yeah.
All land required from required by the central government of public sector purpose concerning public interest first acquired by the state government and lease out to the concerned department or agency or party subject to approval of the government. Leases shall pay to the government a premium equivalent
No. The lessee shall pay to the government a premium equivalent to the cost of the compensation paid to the landowner plus on payment of annual land revenue as per the rate as may be prescribed from time to time.
Yes.
That means this acquisition which will be made by the Nagaland government will be the acquisition on the not on the rental. This will be a total acquisition under those provisions.
Yes.
And you are to therefore liable to pay the amount of the compensation to the government so that they get it. Then you have to pay if you are going by this. You can't say tomorrow that we don't want the land. If this is the notification, you pay that amount. They will lease out, the government will lease out this land to you. Don't worry, don't have the ownership of that. You don't require the ownership. But what will happen is you lease out the land to, you pay the compensation to the state and the state will pay to them matter instead. The government will lease out the land to you.
Yes, and we have to.
The government of Nagaland will lease out the land to you, but the government has to acquire the land from them. And what will the government, therefore, the requirement is you are to pay to the government The entire amount of compensation, awarded amount, and thereupon you get the land on lease. That's what is there.
It was not challenged by.
You are aggrieved. Therefore, if you cannot return the land. The question of returning the land does not arise. It is between you and the government of Nagaland. You do whatever you like. But if the land has been acquired and you want it on lease, you have to take this. You can't take it down. Now, because the land cannot revert back as per the 65 Act to them, unless there is a sale deed. The government has to allocate the land, settle the land with them. Back. Huh? Cannot be. Once an award is passed, the land cannot be in their name. The land has already, the title has already gone.
But dear Mayor, yes, as per dear Mayor official documents, land is still in their name.
Mr.
Yes.
I don't need to further say.
Yes.
So the only way out is you pay the entire compensation and then take it on lease. Now the question is, when are you paying the compensation? They are not concerned. Their concern is, you want to go under section 12, go, but it can't go beyond that. The problem arises is, although this particular provision, kindly see here. Where is that second volume?
Page 21, Lordship.
Page
21 in my book.
21. No, not here, not here. Not in this book.
It's 27.
And not in this book. This is the first edition.
Oh, no, volume 2. Volume 2.
No, this is the first edition, not the first edition. You are having the first
I'm
edition.
having the first edition.
Page?
Is it volume 2, Lordship?
Page?
27 is section 12.
Page 27. Section 12. The collector may, in every case where any person aggrieved by an award made under subsection A, make an application requiring A, subject to the provisions of A, make a reference. Subject to the provisions of land acquisitions apply in respect to any reference made to the court under subsection 1. So, if we are to apply the Land Acquisition Act 1894, the authority cannot reduce it. Then your section 12 becomes useless. You don't want that. That is the biggest problem. The act is faulty. This should have been similar to a provision like the NHAI Act, where you have 3G, wherein any person can go and it can be reduced. But here there is no provision of reducing, because the court has to go as per the Land Acquisition Act.
So repetition was final, it was dismissed on only this alternative remedy is there. It was the objection when dismissing the repetition.
No, your repetition was dismissed by that court.
Yes,
on the ground that you had an alternative remedy. You had an alternative remedy, but the remedy was not effective. That would have been that case. The remedy would not have been effective because it can't go down below that amount. So that is a review to be done. But as of now, that repetition is dismissed.
That is true.
Can't help it. Filing a review does not, there is no stay to that.
Yes.
So under such circumstances, that has gone. So the only question now is, you are to pay if you want the land. And if you don't want the land, tell the government state. But have you mentioned after this, all these notifications out there in 2012, informing you that you don't want this land? Don't give us this land. Now, all this time after, can you now say that?
Understood. I understand.
Lordship, if I may.
I think, Mr. Mehdi, I think you should advise your client to immediately pay. Because now if I apply, If you see that particular judgment in the case of Indore municipality, you may be in much more trouble.
Only some time may be allowed because this is because on because here the new officially is there. He is not.
The fund is not with the officer. The fund is with the government.
Yes, the government approval is-
Why you are not giving it? It's a poor lady out there. You need to pay.
Ministry is approval is-
She has lost the rights on respect to land from 1984.
Yes, but here so many debate is there. This I have got the original agreement. But although it's not relevant, I only want to read my. This lease agreement was made on 1984. And I think this I have some shock my this land the lease shall be commenced from 1st November 1962. 1984 lease was this lease was made, but the sentence was lease shall commence on 1st November 1962. Everything is there, something is there. Because if it is 1984, then there cannot be from the lease shall be commenced from 1962. This original lease is there. So all this thing is happening there. And but now
This lease agreement was very much there with your officials
yes, let's do
all this while. So your officials very well knew about this system. Then the question is, when are you paying?
So let's go. So this sometime at least sometime maybe around 3 months time may be given this. 3 months ministry approval will be required. Ministry approval will be required.
Whatever may be, that you have to take it.
Yes.
Yes, madam, you have come all the way for that? For what? Oh. Huh?
Retired. He also retired. Now new is office. Contempt is the violation of this order of the division bench as well as a single bench.
No, the matter went to Supreme Court. The Supreme Court dismissed it.
Supreme Court only it was withdrawn.
Huh?
It was withdrawn.
So, matter ends. What was the direction passed? No, by the division bench.
Division bench, their observation was made.
We do not find any merit in the present appeal. At the cost of repetition, we would like to reiterate an award that has not been challenged by the appellant at any point of time. We are also reviewed that it is now open for the appellant to take a stand that they will make payment of compensation only after the state government makes the payment of compensation. The appellants have already made aware of the compensation. We accordingly direct the appellants to make the payment of compensation by depositing the compensation amount as per the award with the Deputy Commissioner within 4 months from the date of receipt of the certified copy of this order. What is the date of this order?
Then Lordship, there was an extension given.
No, just 1 minute, just
7/11/19.
7/11/2019. Then an appeal was filed.
Yeah.
Where is the appeal? Appellate order?
Appeal dismissed.
Appeal by which appeal?
Lordship,
Lordship,
may kindly come to 148. Lordship is having the contempt petition.
No, any of them. Where? In your that
This is
application?
this is my,
dismissed.
this is the affidavit in opposition in the writ petition.
Oh, okay, let us say.
Then after this, page 148, after this,
148. Mr. Engavati, the then Councillor VMN, by this application, the applicant so and so 4 months extension of time for obtaining decision of the committee on the order dated demand passed in writ appeal number 4/2019. 4/2019
yes.
is, what is the order?
Judgment of the division bench, 7/11/2011 or 2019.
Okay, so this order,
Yes.
you were given 4 months.
Yes, yeah, it is everything is there.
Then you have sought for extension.
Yes, madam.
On the submission that the applicants are seeking 4 months extension to obtain the decision of the Ministry of so and so. The Therefore, it is not the case of the applicant. They are seeking further time for the year implementing month. It preposterous that the Ministry of has competence to take a decision on the judgment passed by the accordingly the ground on which the prayer is referred is rejected, as the court cannot permit the Ministry of Defence to take a decision on the judgment and order passed by this court, who may either implement or assail it. Nonetheless, to the now against that you have filed a
My lord.
SLP.
now
SLP.
now in the contempt
Page
who-
152, madam.
now the question is in the contempt
Yes.
whom have you made party?
Defense Secretary, my lord, and the Director of Procedural Regulation and Secretary.
Huh?
Lordship.
You have made the
Contempt,
party
yes.
to secretary, yes. We will have the secretary IS, Ajoy Kumar.
My lord, he is retired, my lord. Then
Who is there now presently?
now he is a new one is there. I've already informed my lord.
Who?
Was just informed yesterday, I mean, before yesterday,
Yes.
some new person has come,
New
that's what he said, told me. Just the before yesterday, Lordship, the secretary.
When I came to know, I informed the secretary is now. And my lord, the present chief engineer also my lord retired, my lord. My pen is appearing to respond five.
Then I think, Mr. Imti, you do one thing, you make those people party,
Yes, I'll have to make them a party.
you make them party,
Yes,
you,
I'll have to issue them notice, my lord, first.
yes, you have to
Then
issue this
repeat them again,
notice.
yes.
Issue your notice, because you see, there has been no extension granted by the court.
No.
So under such circumstances, you issue the notice for forfeit
Yes,
and then you file an application.
Lordship.
And I think then only the thing can be proceeded.
Yes, Lordship, the secretary, I was just informed day before yesterday that the secretary has retired and also somebody, the chief engineer,
Chief engineer also, my lord.
is somebody on officially basis right now. The
No,
other
we are
person-
not concerned with the
Correct.
chief
All right.
engineer. Who is going to make the payment?
Is the
Secretary, Ministry of Defence.
Yes, Lordship.
No, Ministry of Defence is there, but
Mm.
anybody else? The
Then the-
director,
Director
whether
General.
this person is there,
Yes,
Director General Rajiv Chaudhary,
yes, my lord. Now,
Now,
respond number
now
six.
whether he is there or not.
Lordship, respondent number 6. No,
We will have him in person.
Lordship,
No,
respondent number
this is
6.
a contempt which have been violated. Sorry,
Yes.
we don't require the IS, this
Lordship,
we
number
will have
6.
number 2.
No, it's respondent number 6 right now, my lord.
Oh, that's
Ah.
one number 6 is very there. We'll have him. He has to, this is a complete violation of this order. You have sought for time for in 2022 for doing it. And in spite of that, you have not done that. This person cannot go on like this. On the basis of it, it is a violation. No, there was no granted, no extension granted from 2000. 4 years have gone.
My last chance, my last.
We'll have
chance.
it tomorrow.
My lord,
Tomorrow.
he's from Delhi, my
We
lord.
want, huh?
He's from Delhi, my lord.
No problem, video link. Video link, when is he paying? Else, from there, we will ask the officers out there to arrest him on contempt. This is not done. How can you, understood, now the moment you are asking for 3 months, you are saying 3 months. If I grant you 3 months, it would be in violation to the order passed by the division bench, whereby there was a rejection of granting you 4 months. This order, kindly see this order passed by Justice Surana. Makes it very clear. You can't do that. 12/2020, this has been rejected. So,
Only thing, my lord.
nothing doing.
My lord, may I submit-
Respond number 6.
My lord,
Let him be
may-
present tomorrow.
My lord, may I submit, my lord? May I submit, my lord?
We'll have it by video. This is a contempt that we are not concerned with anything.
only
There
one.
is a direction categorically passed by this.
My lord, one moment, my lord. My
No,
lord.
nothing doing.
My lord, only this proposal also, this on the basis of this, my lord, we have the proposals also sent, my lord, is on the approval from the ministry is, my lord, waiting, my lord. Ministry. So, my lord, this, the DCP also, my lord.
You have, what is your, in this particular place, what are you having out there?
That place, my
Huh?
lord. This, my clients.
No, apart from that, what are you having there?
No, only this, the only one road.
No, not their land, remaining. What are you, what assets you are having there?
This is one of the headquarter of
Okay, we attach the headquarters. You don't do anything, we'll attach the headquarters. If you don't pay, we attach the headquarters. You cannot go like this scot-free. The order was passed in 2019. 2020, there was a rejection. And then upon now you are asking another 3 months. We attach the headquarters. Don't do anything. We'll ask the DC out here. Where is that? Dimapur. We'll ask the DC to immediately attach it. Go and file. No. Tomorrow. You have to come up with that sanction. Sanction of that particular amount. There is a rejection by the division bench. And do you have the audacity to ask me to give me another 3 months? What is this 3 months business? You want to take this court for a ride? Then we'll attach the property. Don't do anything out there.
I also inform this.
The entire 110 bighas which you are having and acres, attach it.
Official chief engineer is there, madam. I inform him, madam. He is there, madam.
Who?
Official chief engineer is there, madam.
Yes.
So make call him, madam. Because he is there.
Do something. Not taking things for granted.
So I inform him to present here, madam.
No, I have not asked his presence, but the thing is, you can't take things for granted.
On my request,
I would have understood. Yes, you are asking for the first time 3 months. Okay, I would have granted you. But when the division bench has already rejected on the thing that the ministry is thinking as they are going to do, then you file an appeal, you withdraw it. The entire thing has been taken into account by the division bench. This court can't sit over it now. Where is that place which requires to be attached?
Midland Dimapur.
Midland, 110 acres.
It's right in the heart of the town, actually.
Yes. You see, what has happened out here is this. 2019, there is an order passed by the division bench directing you to pay the awarded amount. Matter goes to, there was in 2020, you sought for time for 4 months that you will take their decision out there, which have been rejected. Thereupon, you file an SLP before the Supreme Court, you withdraw the appeal. Now you are liable to pay that amount. Why haven't you paid that amount? And this court and your lawyers out here is asking for time. The question of granting you time does not arise because the moment I grant you time, it would be in amount to violating the orders passed by this court. The division bench more particular. How do you take care of this situation? You cannot say that we don't have we are not going to pay. And this is not the first time it has happened. This matter is going on for the last 4 years. 5 years, to be precise. Then, how do you take care of this situation? Tell me. You are the?
Sir, I'm Colonel Anurag Rawat. I'm officiating chief engineer of the project.
Tell me, how do you do it? Or you have taken this court for granted, this orders or passed by this court has no value? Something like that?
No, sir.
Then? What do you propose?
Sir, I have to inform the Director General.
Does the Director General does not know what has happened all this while from 2019 onwards? There's a contempt matter pending, and the files are getting bigger and bigger from time to time, nothing else. The person is not getting. And secondly, isn't it public money? At the end of the day, you have to pay. There's no worry, there's no quarrel with that. That award cannot be set aside. Who is going to pay the interest? The interest is accumulating. Are you aware of that? The interest would be 9% and 15%. Who is going to pay? You're a taxpayer,
Yes, sir.
so your money is being taken into account. So the interest is accumulating. Although this act may not say, but he is entitled to the interest in view of the Supreme Court judgment, 9% and 15%. Then how do you take care of that situation? Tell me. The amount which was 6 crores in 2012, now it has gone tripled. It will be around 18 crores. How do you take care?
I have to inform the voters, sir. Director General voters, sir.
Okay. We sealed your place out there in Dimapur immediately and put it for sale. Anybody purchasing it, fetching him the amount of 18 crores, he gets it. Direct DC to sell, put on sale that entire value of properties and all. You don't have anything out there, I suppose, important things. You put it for sale. If the state doesn't have, the union doesn't have the money, on the face of it is in violation of it's a contempt. Eight. Why? There's something lucky day. Then? Why 8? We can give you time till 4th. Get your instructions. 4th. When are you paying it? On affidavit. And make it 5th. File an affidavit and on within what time you are going to pay. Because this is on the basis of a gross violation of the court's order. File an affidavit. There's no quarrel with that. Write it down. Mr. Medhi, we are not concerned. Your personal difficulties or whoever it is. We are concerned with the orders passed by this court being violated right, left, and center. Just write. In both the matters, same order. A plot of land belonging to the respondent number 2 in the writ petition was acquired under the provisions of the Nagaland Land Acquisition and Requisition Act, 1965. By an award dated 25/10/2012 in land acquisition case number REV-12/D/2012/1442. The said land was acquired for the petitioners herein on account of non-payment of the awarded amount. A writ petition was filed being WPC number 114/2004K/2014. And the said writ petition was disposed of by the judgment and order dated 15/5/2017. Directing the petitioner, directing the project SEWAK, SEWAK, all caps, to pay the petitioner, pay the respondent number 2 herein through the Deputy Commissioner Dimapur, the compensation amount of rupees 7,69,45,120 along with interest as awarded by the award dated 25/10/2012. Within 6 months from the date of receipt of the said order. It was also mentioned that in case the project SEWA failed to do so in time frame, within the time frame, the government of Nagaland should pay the same and get reimbursed from them. Thereupon, a review application was filed being civil review petition number 1/K/2018, seeking review of the order dated 15/5/2017. The said review application was dismissed by an order dated 21/6/2018. The petitioner herein further preferred a writ appeal before this court. Against the judgment and order dated 15/5/2017 in WPC number 114K/2014. By the detailed judgment and order dated 7/11/2019, the said writ appeal was dismissed directing the writ petitioners herein to make payment of the compensation amount by depositing the compensation amount awarded as per the award dated 25/10/2012 with the Deputy Commissioner Dimapur within 4 months from the date of receipt of the certified copy of the order by the respondent number, appellant number 3, who is the petitioner number 3 herein. Petitioner number 3, na? He was the appellant number 3 was Chief Engineer Project Sevok. And he is what now here?
My lord, the appellant number 1 was the union, appellant number 2 was the Director General, and appellant number 3 was
it's the same. Respondent number 3, petition number 3 here. Thereupon, the respondents herein, the petitioners herein, filed an interlocutory application before the division bench of this court, seeking 4 months extension of time for obtaining decision of the competent authority on the order dated 7/11/2019 passed in writ appeal number 4/2019. The said interlocutory application was registered and numbered as IA (civil) 72/2020. The division bench of this court, by an order dated 2/12/2020, rejected the said application, observing inter alia that the Ministry of Defense had no competence to take a decision on the judgment passed by this court. Thus, Ministry of Defense either had to implement it or assail it, for which this court, the division bench of this court, be that as it may, the division bench of this court granted time till 31/1/2021 to implement the judgment and order dated 7/11/2019 passed in writ appeal number 4/2019. Thereupon, a special leave to appeal was filed before the Supreme Court. The same was withdrawn by the petitioners herein on 23/7/2021. The same, it did not stop there. The petitioners thereupon filed a writ petition before this court, being WPC number 86/2020, assailing the award dated 25/10/2012. In respect to which there has been categorical directions passed by the division bench to make payment. The said writ petition was dismissed with a cost of 50,000. Be that as it may, that said dismissal was made on account of the availability of the alternative remedy under Section 12 of the Nagaland Land Acquisition and Requisition and Acquisition Act 1965. In the meantime, while the said proceedings was going on, the petitioner, the respondent number 2 herein, filed civil original contempt, so the contempt proceedings, being contempt case number COPC number 15/2021 on 13th of November 2023. 2023, na?
21.
Oh, 21. In the meantime, that file. First, in the meantime, yeah. The record for the reveals that pursuant to the order passed by this court, dated 10/3/2022 passed in WPC number 86/2020. An application was filed before the Deputy Commissioner cum Collector, Dimapur District, Dimapur, on 17/6/2022. Under Section 12 of the said Act of 1965. The said application is Annexure F to the present writ proceedings. A perusal of the said application shows that the petitioner herein is aggrieved on the question of the on the aspect of the compensation, which as per the petitioner should have been much less. The said application, however, was rejected by an order dated 26/5/2023, which have been assailed in the present writ proceedings. At this stage, this court finds it relevant to take note of Section 12 of the Act of 1965, which permits a person aggrieved by an award to seek a reference from the collector for a decision of the court. This court also finds it relevant to take note of subsection 2 of Section 12 of the Act of 1965, which stipulates that the provisions of the Land Acquisition Act 1894 shall mutatis mutandis apply in respect to any reference made to the court under subsection 1 of Section 12. At this stage, this court further finds it relevant to take note of Section 25 of the Act of the Land Acquisition Act of 1894.
Issue of limitation also, 18.
That we are not. Section 25 of the Act of the Land Acquisition Act of 1894, which stipulates that the reference court cannot reduce the compensation which have been awarded by the collector. Under such circumstances, it is the opinion of this court that the petitioners herein would be liable even after filing an application under Section 12 to pay the amount awarded compensation this way or that way. Today, an affidavit has been filed by whom? By the an additional affidavit has been filed by the petitioner number 3. stating inter alia that the petitioners never intended for acquisition of the land, but only wanted that the state of Nagaland should acquire the land from the petitioner, from the respondent number 2, and thereupon lease out the land to the petitioners on the basis of the office memorandum dated somewhere. On the basis of the office memorandum dated on the basis of the office memorandum dated 21/2/2005.
That is not, dear, my lord, the reply, my lord, they annexed that.
You are saying that, isn't it your case? That
Now, what happened in this 2005, my lord, this first, my lord, the government required, then again, lease, my lord. Only our intention was, my lord, we for lease, my lord, of the.
no, lease you cannot. Lease you cannot.
Yeah, that was our.
The land has been acquired. You can under
But it is not our intention, the government will.
On the
require 2005.
21/2/2005. First, this court have duly taken note of the said notification dated 21/2/2005, which categorically also shows that a lessee shall have to pay the government premium equivalent to the cost of compensation paid to the landowner, plus on payment of annual land revenue rent per rate as may be prescribed from time to time. Therefore, under such circumstances also, the respondent, the petitioner's hearing, has to pay to the government of Nagaland the cost of compensation of the land to be paid to the landowner, that is the respondent number 2. This court further finds it relevant to take note of that a stand is being taken that the petitioner's hearing does not require the land. However, it is very pertinent to mention that once the acquisition, that unlike the provisions of, Madam, there is an act, Right to Fair Compensation Act, which permits the vesting of the right back to the owners. There is no similar provisions either in the Act of 1965 or in the Land Acquisition Act of 1894. Under such circumstances, the stand which is being taken in the additional affidavit is nothing but to hoodwink this court from not paying the compensation or complying with the directions passed by this court. Mr. S.K. Mehdi, the learned counsel appearing on behalf of the petitioner, submits that some time may be granted so that he can obtain instructions in that regard. Mr. So-and-so, your name is Anurag Rawat. Colonel Anurag Rawat, who is also the officiating chief engineer, is present in the court, who also submits that he would like to inform the authorities as to what further steps is required to be taken, taking into account that on the face of it, there has the orders passed by this court, the division bench of this court, have been flouted. This court, as a last chance, grants time on 7th of March 2024.
Instead of
Full
7,
stop.
8,
Make it 6th.
Actually, there are some cases taking principal bench, the land matter.
Don't worry, I'll in principal seat. Okay, I'll be there. I'll grant you time there. Don't worry. 7. Okay, 8. On 8th of March 2024. Full stop. On the same date, the respondents, either the petition is hearing as well as the contemners, the respondents in the contempt application, number 15/2021, shall bring on record their specific stand as to when the amount would be paid by way of an affidavit. So failing which, this court shall take further actions as envisaged under the provisions of law against those officials.
For 180